A very good morning to everyone. I'm Dr. Karma. Today I'm going to jog your memory on medical legal jurisprudence. I know you know about it, a little bit from me also, and something that after BNS has come, certain changes has been done. For sexual offense survivor, there has been certain changes that has been implemented after the state of Jharkhand versus Salindra Kumar case by the Supreme Court, one of which was the medical examination report of the victim examination, which is 13-page long, isn't it? But it has not been implemented in Sikkim yet. So this will be the content for today, although not in the same order, but we will be covering this topic. The first being forensic medical care for victims of sexual assault, the guidelines of it, mostly being the two of the functions. One is comprehensive health care and second one being the evidence preservation and handling. Guidelines for interviewing a child, forensic interview protocol, treatment and follow-up care, handing over forensic medical reports and forensic evidence, etc. to the police, prerequisites of the health facility along with material and infrastructural requirements. This is the overview how doctors and police are supposed to act. If you want in the gist, you can have it in your cell phones, right? The foremost important thing is the consent of the survivor if the survivor is more than 12 years of age. Usually we ask this, what is the medical legal importance of age 12? Age 12, what I mean is, at age 12, what is the right of the child at age 12? At age 12, don't worry, I'll give you the PowerPoint. I'll give you the guidelines, I'll give you the resources also. If you can just focus right now. Okay then. Consent, isn't it? The medical legal importance of age 12 as a child, what you can do, what the child can give permission for. The first thing is medical legal examination. Not the surgery, not the operation, but medical legal examination of the case for whatever the patient or the child has been brought into. Even if the guardian says, kindly examine my what, but if she is more than 12 years of age, less than 18 or more than, but she refuses to get examined, then in such cases, rightfully whatever the child wishes for, isn't it, will be going forward with that. If the child refuses to give consent for examination, we are not going to examine. If the child gives the consent for examination, of course yes, isn't it, we are going to go forward with the examination, provided we also have to handle the situation tactfully, isn't it? We have to bring in, give the confidence to the parents that whatever the child wants, we have to do it, because in the future that's her life or his life. In POXO cases, it is gender neutral, isn't it? Because in the future, what will happen is, the person, the experience that he or she had in the past, isn't it, is going to build upon his personality, right? That is going to have an effect. So if one feels that he or she does not have the control on his or her own body, isn't it, that is going to have a worse impact in the future. Considering that fact, that we are going to take the consent after 12 years of age. Why 12 years of age? Because even in the testification in the court, isn't it, one has always said, isn't it, that if you can understand the nature and consequences of the act, then you are allowed to give or testify in the court, isn't it, give evidence in the court. So in such case, considering that 12 is the understandable age, the one has the right to be in control of their body, right? Hence the age 12. I hope you won't forget that age. It's 12. So one doesn't, if it's difficult to remember. The first and foremost thing, as a doctor, first aid, the treatment comes first, isn't it? Whatever the patient has been suffering for. When I said consent, isn't it? It is the same form, but it has 3 different clauses. The person can give consent for examination, but refuse to give the consent for evidence preservation, or can give consent for evidence preservation but refuse to get examined, or give consent only for the treatment and refuse for both. That is up to the right of the patient. We cannot force it. So, having been said that, if the person refuses to give the consent, isn't it? Refuses to give the consent, the one is supposed to take informed refusal also. The person has refused to get examined, preserve the evidence, but has given the consent for getting the treatment, isn't it? Everything has to be on document, because if in the court you are put up in the court, isn't it? So if it is not there in the document, it means you have never taken charge of things, isn't it? It was never done. So everything has to be documented first. Consent happened, then first aid was given, even if the person refuses and if it is emergency, isn't it? In such cases, the person, because the act is done in good faith, isn't it? Even with the consent, without the consent, treatment can be given. Treatment can be given. Then comes your history taking, then physical examination along with local. When I say examination, you examine the patient with the thought that I am going to treat the patient, but you also have to consider the fact that evidence need to be preserved, isn't it? So if the patient is brought to the hospital, the patient might sometimes not give the true history, isn't it? So if the police has brought the patient, you have to inform the doctor that the patient is so and so patient, isn't it? So that when she gives the treatment, the evidence are also preserved. Because once the evidence is removed from the body, it is not going to have any importance. Considering the Locke's principle, isn't it? The evidence the preservation is based on the principle that when two objects come in contact with each other, there will be exchange of materials, isn't it? Based on that, we are collecting the evidences. So we have to make sure that the evidences are collected without much contamination and tampering, knowingly and unknowingly. Okay? Then comes your treatment part. That is treatment for all the injuries. I was told that there might be doctors also along with the policemen, so I included that also, but let's skip that part. So then comes the age estimation, isn't it? Usually in the court, if the person has birth certificate, 10th certificate, any other documents which can certify the age, then in such cases age estimation is not required. That takes the upper hand, isn't it? But in such cases where there is no such identification data or the age estimating certificates, then in such cases we are supposed to do the physical examination, dental examination and radiological examination. I'll let you know, and this is also important for you, because unless you know, you are not going to ask for the doctors, isn't it? What do you want exactly? Then comes evidence collection. It has to be dry packed and handed over to the police, and documents also needs to be handed over to the police. We will be learning about it in detail. So as a healthcare providers, there are two things that healthcare providers must do. First is the medical treatment and the psychological support. The second one being the evidence preservation, collection and ensuring that it is of good quality. Now, comprehensive healthcare response to the survivor is something that is not new. It has been implemented, but it has not been tabulated and has not been put into the SOP, isn't it? But now it is said that providing necessary medical support to the survivor of the sexual assault, that should be the responsibility not only of the doctors but also of the law enforcement agency. Establishing a uniform method of examination, and how can we ensure that? That is by providing safe kit. There is a safe kit, sexual assault forensic examination kit. If you must have heard about it, idealistically, the policemen are supposed to bring that, right? We are supposed to break it, and then once that packet is used for one victim, we are supposed to discard that. Then another safe kit needs to be broken. Having said that, it would be ideal, isn't it? But if not so, we have to try and make our own, isn't it? So in doing so, make sure that the evidence is not harmed or tampered in any way, isn't it? Then comes a written informed consent. If you have taken the consent, the victim has said yes, isn't it? But if you have not documented, it is known to cause paternalism. If you don't take consent, the opposite of consent is paternalism, isn't it? That you have acted as a parent, and for example, if I examine a victim, okay, without her consent, I have caused an injury. Getting my point, what I'm trying to say? So that is known as paternalism, acting on behalf of the patient when he or she is capable to take his or her own decision. So please avoid doing that. It is an offense. First contact, psychological support and validation after the traumatic experience. Many a times when doctors do refer them to the psychological department, but as a law enforcement agency, isn't it, we tend to skip that part. We do not think about the psychological support that the victim requires, because incident occurred, many people will be sympathetic towards the family, towards the victim or the survivor, will be there, isn't it? But eventually, as the years pass by, the person will be known by that name. right? By that incident, isn't it? That cannot, the one incident cannot be the entire defining character of that personality, right? So in order to give them the second chance also, the victim's names has to be off the record, right? So off the record, but it does not mean it never happened with that person, right? So the person needs psychological support, some recognition, some sort of validation that it was not her fault, right? So for that, psychological support and validation. Maintaining a clear and foolproof chain of custody. Referral to appropriate agencies for further help. Example, legal support services and shelter services. Many a times, the victim family do not report. Even if the victim do not report or refuses to give the consent, it is our duty to tell them how the law can help them. Many a times it is seen that the victim refuses to complain against the accused because they think that all the burden of the expenses is borne upon them. So you have to let them know how the state is going to help them, isn't it? How excuse me, how they are going to be helped, guided, and if needed, consultation and compensation also can be awarded to them through the court, right? Referral to the appropriate agencies. Now the purpose for medical and forensic examination. When police agent, like law enforcement agency, they send the victim to us or the survivor to us, what is our main idea? It is to establish whether a sexual act has been attempted or completed, as well as any form of non-consensual sexual touching was there or not, isn't it? Not only penetrative, non-penetrative offences are also sexual offences. Whether such a sexual act is recent or not. Few things that I want to mention. If it is non-penetrative sexual assault, please do not ask the medical practitioner to save those swabs, vaginal smear, because it is not related to it, isn't it? Because it is non-penetrative. I will be explaining to you in detail. This has been explained, should be known by the doctors, but if you get to know, isn't it, it will help you administer it better, isn't it? Whether we also have to establish whether the sexual act is recent or old, whether such an act was forcible. However, if there is absence of any physical injuries or signs of struggle, isn't it, that does not mean it was consensual. Why? Can you think of the scenario where there is no injury, no struggle, but still it does not imply consensual act?
It could be the survivor could have been drugs or given any intoxication.
Do you want sweet? I could throw you one. Do you want it? Okay, reward for you. I'm extremely sorry. That's true. Thank you. So one of the situation could be that, isn't it? That the person was drugged, isn't it? Or was not in the senses, isn't it? Or it could also be so that the person was under the impression that the person whom he is marrying to is that guy, the husband, isn't it? Whereas he might be marrying 1,000 people, isn't it? It must be a scammer or something, isn't it? Even those are considered to be an assault, isn't it? Under the impression that he is somebody else. All those are considered to be non-consensual, isn't it? If validity of consent is questionable, then verifying age of the survivor in case of pre-pubertal or also girls or boys is important, and ascertaining influence of alcohol or drug administered to the survivor. Providing treatment of sequelae of the sort and appropriate referrals to the survivor. Any queries, please ask. You can raise your hand. So prerequisite are the healthcare facilities. One is the I didn't know it was for the police. Okay? Otherwise, I have a guidelines. You can scan those things. The scanner. I have a QR code where a police friendly hospital which is non-threatening and the conduct of the police officers is mentioned there. So you can scan it. There is a whole document. You can go at your home and at your leisure time you can read through it. Okay? But for now, it has to be non-threatening, quiet, private. There should be adequate waiting space for the survivors. There should be sufficient space, lighting, comfortable examination table, and well-trained staff. Not only that, not only they should be trained at doing what they do, skillful, but also they should know what sexual offense is, what is the physical and mental health of the victim, and how to help them. In case of female doctors, many a times they ask for female doctors, isn't it? What if there is no female doctor? In such cases, even the male doctor can examine the patient, provided there is a female attendant. In case of minor or person with disability, his or her parent or guardian or any other person with whom the survivor is comfortable must be present. Preferably if the child is under 18, then it is advisable to be examined by the female doctor. Unless the survivor requires in an indoor stay for treatment or observation, admission should not be insisted upon. Obviously, if the person, let's say, has delivered, known to be less than 18, isn't it? It falls under POXO, even if the person is husband and wife, isn't it? In such cases, it falls under POXO. So you should not discharge the patient very easily, isn't it? Very easily in the sense, first you have to consider the fact that she has just delivered, isn't it? Once she is stable, then only she should be discharged. Prerequisites at the health facility, there should not be any delay in conducting an examination because that is the top priority, isn't it? And collecting evidence in cases of sexual assault as evidence is lost with time. In a situation of mass violence, isn't it? Caste, communal or armed conflict, various forms of sexual assault are perpetrated against women and girls. Doctors working in such situations should therefore look for signs and evidence of sexual act amongst all girls and women who came to the hospital, whether they are brought dead or alive. In such cases, the state must provide security to its health professionals. If we have known in the Arjikar Medical College, that is where it went wrong, right? So please consider that fact. If you think that it is beyond your control, do not hesitate to take help, isn't it? It is better to be safe than to be sorry, right? Under such circumstances, so that they may be allowed to carry out their duties without fear or external pressure. These are the health consequences which the person could suffer from. These are the psychological health consequences. Till date, although I have mentioned here in the slide, isn't it? Physical injury, everybody attends to it. The doctors, the family, everybody will attend to it, isn't it? But when it comes to mental scarring or mental consequences, isn't it? Or psychological consequences, not many people attend to it because unless it is visible in front of you, you are not going to say that the person is hurt, right? But asking, talking, validation is important for all, especially the person who has suffered through trauma. Now section 397 BNSS, which also was previously 357C CRPC, says that all hospitals, whether it is public or private, whether run by the central government or the state government or local bodies or any other person, shall immediately provide the first aid or medical treatment free of cost to the victims of sexual offence and shall immediately inform the police of such incident. Section 184 BNSS, sir has also explained it to you a while back, isn't it? That is, whoever being in charge of the hospital, public or private, whether run by the central government, the state, local bodies or any other person contravenes with the provision of section 397 of the BNSS Act, in such cases shall be punishable with 1 year or with fine or with both. Section 184 BNSS also states that examination of a case of sexual assault shall be conducted by a registered medical practitioner employed in the hospital run by the government or by the local authority, and in the absence of such practitioner by any other registered medical practitioner. By registered medical practitioner, I mean the person who is graduated, like MBBS, the basic minimum requirement. If a doctor with MBBS degree refuses to examine the patient, you have every right to take action against that person, right? Does not mean beating up, but within limits. You can always file a complaint, right? You can't manhandle things. So examination to be conducted without delay and a reasoned report. This is something new. This was added after BMSS. That is within the period of 7 days, the report has to be submitted to the police officer. By report, usually what I have seen right now is, I think you have one injury report, you write the complaint on the first page, and at the back of it they write the report, right? That is not the report that was supposed to be filled. We'll talk about it in detail, probably in the second half, if possible in the first half also. Record consent obtained specifically for the examination, exact time of start and close of examination to be recorded, RNP to forward report without delay to the investigating officer and in turn I to the magistrate. Now building a rapport with the survivor. Everybody knows what to do once the complaint has come. You will take the survivor to the hospital, talk to the doctor.
Can you go previous slide? Time of start and close of examination to be recorded. is to be done by the medical officer.
It was always there. It was always there. It was overlooked.
But usually the MNC forms have two sides. On one aspect, the IO fills it up and sends it to the hospital with the mention of the time. Now, when the medical officer examines the victim, okay, he or she only records the start of the time when the victim comes in front, but the closure of the examination is not written. Now, usually what happens is, on our side, when the survivor comes back to the Thana, then the SHO or the IO makes a GD entry with the date and the time. Now, there is a big delay from finishing your actual examination and the time when it is recorded, because the closure time is not recorded. Okay. Another aspect which I would like you to clear up in the slides to come is, usually the medical officer refers the survivor to a gynecological examination. Usually not in most of the cases. In any sexual offense case, all the SHOs will agree with me, the survivor is forwarded to a gynecological expert. Now, the setup is such that all the hospitals do not have a gynecological expert. Okay. So, in that instance, is the medical examination over when the MO signs it and finishes with her or his examination? Then again the IO has to go and take the survivor to a gynecologist. In the gynecologist also, she has to mention the date and time of starting and the closure also of examination.
I need one clearance. Who writes the report?
Who writes the medical officer?
So that is what I meant. What we are talking right now is the reporting, the examination of the victim, right? The first, excuse me, I don't want to mention the investigating officer, I had just come for the consultation, but then the IO, what he or she had done was, she had first, the survivor was first examined by the medical officer, then secondly was referred to Singtam, and then thirdly to the Sochegan. There were 3 reports. The court, which report will the court give importance to? The first report, isn't it? So the investigating officer, she kind of, I wouldn't say boshed up, she did to the best of her ability, isn't it? But that in the eyes of the law is boshed up, right? So preferably the first doctor, the whole idea, why I started with the role of the healthcare professional or the services is, first is the treatment of the patient. The second is the evidence collection and proper handling of it, right? For treatment purpose, if the medical officer wants to refer it to the gynecologist, sure, why not? We shouldn't have any problem with that. But the reporting, the examination, isn't it, will be done by the medical officer. And that too the first medical officer. She didn't know about it, so she also got to know on job only, isn't it? That the first report is important. The first examination is important. Now, using our common sense, why the court must have said so? Because it is within the 24 hours that the law court's principle of exchange comes into being, isn't it? That is the maximum preservation of evidence that we can have for. And the amount of time that you said for the GT entry, the police officer arranging police and then coming to the hospital, arranging for the vehicle, the family members arranging for the clothes and everything is within 24 hours. I think within 24 hours you can reach any part of Sikkim, right? I think that can be done.
My question is, when a medical officer forwards the victim or the survivor to the gynecologist, okay, my IO will take the survivor to the gynecologist. Okay. So, when we file the charge sheet, we are including both the medical officer's report as well as the gynecologist's report. And sometimes the 2 reports are contradicting each other.
In what
Yes.
sense? Contradicting in the sense one says the presence and one says the absence?
Yes.
Absence of injuries?
Yes. Signs and symptoms. Yes. There have been 3 or 4 judgments where the accused has been acquitted on these very grounds.
That's why I was wondering if the doctors could be here today to write the report, the proper reporting.
The doctors
I was
are here.
here with the
The
slide.
doctors are here.
You guys are doctors? I'm so sorry.
The doctors
Same
are here.
fraternity, so forgive me.
So there our prosecution is in a gray
No, I'll tell you one thing.
area.
Mm.
And when the charge sheet is submitted, one copy goes to the defense. There the defense lawyer sees the
Discrepancy in the reports.
and says that the victim has been forwarded to a gynecologist.
Mm.
Now, where is the gynecologist report?
Mm.
Where is the gynecologist who will be or she will be standing in the dock to give her deposition?
Mm.
And there have been certain instances where the findings have differed. Now, as per this, and as per the 24-hour rule mark, the medical officers are the best to give the report. Okay. Now, what happens is, even the MNC form which is being filled up by the medical officers and which is being taken. Now, when the contradiction emerges, our case fails because medical officers and the gynecologists are the main person to determine whether the victim has suffered any sexual offense or not. Now, when there is contradiction on these reports and it's not very clear, the case fails. Then, as sir said, MHA has a aim of getting
90% conviction.
90% conviction rate.
That's quite far-fetched.
That is quite far-fetched, okay? Because I don't think CBI has 90% or thing conviction rate. But the question arises, and in the field,
Mm.
the IUs and the SHOs whosoever are here, they have faced this problem. And when they come up to us, we say, the supervisory officer says, he include both the reports in the
See,
charge sheet.
I can always tell you what are the options, right? It is up to you to choose, right? I cannot tell you to be
Yeah.
right. One thing is, the medical officer who comes, the doctor, the RMP, first RMP who comes in contact with the survivor is the one who is going to preserve the evidence, gets the examining done, isn't it? If the second doctor or gynecologist happens to examine, isn't it? If she is very sure of her findings, isn't it? Then in such cases, the public prosecutor can say that he lacks an experience, she doesn't lack in one, isn't it? During treatment, they found out these injuries which were internal, isn't it? That could have been done. That is one thing that can be established, provided you have a better communication with the PP, right? One is that. Second is, what I see is the discrepancy among the findings that was seen first by the doctor and second by the gynecologist. Let's say if it is injuries like bruise, isn't it? If there is immediate injury, contusion, bruise, it won't be seen. Within 48 hours it can be seen, isn't it? So it is always challengeable in the court. The same medical officer, otherwise you can help the treating doctors, isn't it? Say that, please ask to write review after 24 hours. And within that time, gynecologist will examine the patient, isn't it? And will come back and then he can write the injuries again, isn't it? After 24 hours of my examination, these are the injuries seen, isn't it? The sample will be preserved. The idea of preserving, getting the examination done and completed within 24 hours is the fact that the victim does not go through secondary victimization. That is the whole concept of it, isn't it? You can play around it. These are the options, isn't it? Having said that, I know a lot, okay? But when it comes to ground level, okay, so I can give you the options, but it is for you to practice. I won't claim tall things, isn't it? These are the options. Legally, if I use my brains, on top of it, what I can say is, if it so happens, you can either ask the medical officer to be clever and cunning, isn't it? Like, please write review after 24 hours. You can get it re-examined after 24. If he or she is that uncooperative, you can write to the medical superintendent saying that, what is this report? There's discrepancy in these two reports. So come up with one. Set a medical board and come up with one report. Right? Include the medical officer, include the gynecologist, come up with one report. As simple as that. So, should we continue?
Yes.
Would you mind, no? You won't mind, no? The medical board is said, because at the end of it, the justice should prevail, right? One thing, as a doctor, what we must understand is, we as a society in the community are here in the system, isn't it? One day we will retire. One must understand that concept. As Madhya Pradesh High Court judge rightfully said, isn't it? Once we are out from the system, isn't it? Whatever change we could have made, isn't it? We should make it. Otherwise, once we retire, we will be complaining about the same thing. We will be the victim of the system. So let's change it when we are in it, isn't it, for the good. This is done? Okay then. Then building a rapport with the survivor, isn't it? Obviously we are busy writing complaints, isn't it? Writing the reports, isn't it? But first thing is to build the confidence, isn't it? To gain confidence of the survivor along with their guardian also, isn't it? Explaining them why it is important. Even if they are refusing to give the consent, isn't it? Informed refusal hi le rahe ho, isn't it? Informed refusal. The word is informed refusal. You have to inform them what are their options, what they could have done, isn't it? And what are the facilities provided. Knowing everything in detail, they refuses to go forward with it. Then it is an informed refusal, isn't it? Never discourage the victim, isn't it? Try and encourage them. Never say or do anything to suggest disbelief regarding the incident. The first complaint is that. The first complaint is the police officer did not believe me, isn't it? Or they took it lightly. Or the doctors, they were too busy, they mishandled, the nurses are too loud, isn't it? The doctors did not care for me, isn't it? Those are the things. Because as it is, isn't it? You have seen a child, right? Why a child is forgiven 101 mistakes? Because they are vulnerable, isn't it? If you are a bit louder also, they are going to get hurt, isn't it? As an adult, when we undergo through certain traumas, the first thing, the first thing that one tends to undergo is be vulnerable, isn't it? That is where we need to have empathy for the patient, be compassionate, act as a human, isn't it? Do not pass judgmental remarks or comments that might appear unsympathetic. Is this the clothes that you were wearing? Did you have any boyfriends in the past? Even the Supreme Court had highly suggested that whether the person had relationship in the past or not, what kind of clothing, whether she smokes, drinks, isn't it? These questions are unnecessary and asked to harass the victim, isn't it? Or the survivor, isn't it? So please note that, please do not, if you have certain prejudices, isn't it? Keep it at the back of your mind, okay? And act professionally. Appreciate the survivor's strength in coming to the hospital, as it can serve to build a bond of trust. Convey important messages such as the survivor is not responsible for precipitating the act of rape or by any of her actions or inactions, because the victim, when they go through that event, isn't it, the event must have lasted for, let's say, 5 minutes, isn't it? The person must have struggled in the initial few minutes and then later on gave up, isn't it? That kind of make them feel guilty, like I could have struggled more or something like that. We don't know what is the conflict going on in the victim's mind, right? So in such cases, we have to reassure them, isn't it, that it is not their fault, isn't it? Excuse me. Explain to the survivor that this is a crime or violence and not an act of lust or love, isn't it? Because in such cases, the person tend to, you have heard about Stockholm syndrome, right? Where the victim actually falls in love with the person who has kidnapped them. Such thing, isn't it? And in a community like ours, if I'm not wrong, few years back also, isn't it? If the accused wants to marry the victim, in such cases they try to reconcile, isn't it? But if the person is less than 18 years of age, please avoid doing that, refrain from acting that way. Okay? What is law should be even for all, isn't it? Right? Emphasize that this is not a loss of honor, modesty, or chastity, but a violation of his or her rights, and it is the perpetrator who should be ashamed, isn't it? Having been said that, if the accused come for the examination, isn't it, that prejudices or whatever feelings that you have for now, isn't, take 5 minutes break. Take 5 minutes break, keep it at the back, isn't it, and then get the examination done. Take help of a counselor if required. What I prefer is, once you get the examination done, isn't it? Obviously you will also be having conflicting thoughts, isn't it? Always have somebody to talk to, okay, so that you can start fresh in the new case. So the purpose of forensic medical examination is to form an opinion, to establish whether the sexual act has been attempted or completed, whether such a sexual act is recent, and whether any harm has been caused to then survivor's body. However, it does not suggest that, absence of struggle does not suggest that there is a consent. The age of the survivor needs to be verified in the case of adolescent girls or boys. Whether alcohol or drugs have been administered to the survivor needs to be ascertained. This is the guidelines for the doctors. If you have the QR code scanner in your cell phone, you can scan this. What I was talking about, the Supreme Court in the state of Jharkhand versus Sailendra Kumar's case, this is what the guidelines, they have formed a committee, isn't it? And there was a proper book that was published by the Ministry of Health and Family Welfare, isn't it? So this includes everything, every queries you have, every situation you can ever be in. Everything has been answered, along with the 13 pages examination report. The report that is in the first page written by the police, the report are not supposed to be in the back page with a single form. There are 13 pages that needs to be filled. We will be talking about it later. If you can scan the code, everyone done? Save it. You will be recording it. This is as far as forensic medicine to you is concerned. This is everything that you want to know. Done? Obviously, law enforcement agencies can also scan it if you want to know what they are supposed to do, right? And sometimes when you know that something is lagging, you are not able to build the bridge over the two sequences, isn't it? Knowing this will help, isn't it? Oh, so doctor failed to do this, isn't it?
Excuse me, I think one more issue regarding the contradiction could be because we are not allowed to do finger tests. So
Yes.
we examine only the external part, but in case of gynecologists, they do a thorough examination so that they can find internal injuries. So that could be the reason for the contradiction as well.
Few things that I want to say, few things, not only the report, okay? I think the Supreme Court came up with 3 findings. One was to form the protocol. This is the protocol that was formed after that, isn't it? To implement the protocol and to form this workshop, isn't it, in every state of the country, so that this report is used everywhere in the country as uniformity, okay? The third one is to avoid two-finger test. I'll tell you the importance of it. And the fourth one was to all the medical colleges to use, because the 377 Decriminalization Act, to not to use lesbianism, gayism, basically LGBTQIA plus community in the unnatural sexual offense chapter, isn't it? Those were the guidelines, okay? So now let's come to the two-finger test. Why was two-finger test done? No, I still do not get it. Why was it done? What are we trying to prove? Like a female with a big stature, isn't it? A female with a small stature, or a doctor with a small finger, or a doctor with a big finger. It is subjective. What were we even doing it during those times, isn't it? It is not only uncalled for, I think it is inhumane to do something like that. Unless you are obviously going to give a delivery, vaginal delivery, and you are looking for a cervical dilation. That is a different thing, isn't it? Apart from that, I don't think it is needed. The Supreme Court rightfully reprimanded them for doing that, isn't it? It is not to be done. Should not be done and should not even be discussed also, as far as I am concerned. What injuries you are saying, no, that you are not able to see, what injuries we are supposed to do in examination, I think the Supreme Court has made this format so that you know how to report it. Okay? We as a doctor know how to report it, because apart from the injuries, what we are supposed to report is only the injuries sustained. It has gone down to the extent to say that whether it is hymenal tear or not, even if there is hymenal tear, isn't it? It does not say that the person is or had sexual experience or not, isn't it? It is of no importance unless you are saying that there is a fresh blood swelling, swollen discharge, isn't it? All those things which suggest fresh injuries, that is the only importance that you need. Gynecologists might write whatever they want to write. Okay? First delivery, G2, P1, L1, whatever they want to write, they might write, isn't it? But it lacks significance in the court of law, even if there is a discrepancy, isn't it? I think in the medical board, if they suggest one, isn't it, there should be one forensic medical expert suggesting what is the importance, what is the end goal, isn't it, what we want to write. Injuries, what we want to see is, for example, we'll come to that in the report later. Can we discuss it then? Otherwise it will be a repetition of that. Okay? So everyone has scanned this, isn't it? So this is the report that I was talking about. This is the 13-page report. Everything has to be included. If you can see, name of the hospital, OPD number, inpatient number, name, daughter, son of, address, age as reported, isn't it? Date of birth, sex, male, female or others, date and time of arrival in the hospital, date and time of commencement of examination, brought by name and signature, MLC number, police station, whether conscious, oriented in time, place and person, any physical or intellectual, psychological disability. Interpreters are special administrators, educators will be needed where the survivor has special needs such as hearing or speech disability, language barriers, intellectual or psychological disability. This has to be there. I will give you everything. If you had scanned that previous document, this document is also there in that data.
This is the same thing which is being used as CRS now. It was
In other state, what they do is the police officer has this copy, 13 pages. You know? Every time they bring the report, they bring this document with them.
We are doing it. In Namchi district, we are doing it. Okay. But when the initial stage,
obviously there will be some hiccups in the beginning.
there are some
There will be some hiccups. It's understandable, but not to the extent where you fail to preserve the evidence or something like that. So informed consent or refusal, as I said, isn't it? It includes everything. I, daughter or son of, hereby give my consent for medical examination, for treatment, the medical legal examination for the findings that you are going to see after the sexual assault to establish that fact, and sample collection for clinical or forensic examination. If the person only wants to get it treated, then tick it to here and then cross the others. Okay? And if it is an informed refusal, you have to write it in writing, isn't it? That I voluntarily so and so have been explained everything, isn't it? Considering the fact in my own language, and I refuse to get the examination done, report it to the police. Anyways, you have to report it to the police. Then when the police comes, they can give the informed refusal. Okay? So it also says that I also understand that as per law, the hospital is required to inform the police. And this has been explained to me. I want the information to be revealed to the police. I have understood the purpose and the procedure of the examination, including the risk and benefit explained to me by the examining doctor. My right to refuse the examination at any stage and the consequences of such refusal, including that my medical treatment will not be affected by my refusal, has also been explained and may be recorded. Content of the above have been explained to me in language with the help of the special educator or interpreter or support person, the name of that person, the special educator, the signature of that person, isn't it? And if he is affiliated to, let's say, child welfare, isn't it? That also has to be mentioned from which district it is, isn't it? Along with the sign, date, signature, thumb impression, along with 2 identification mark has to be established. What are the identification marks? Mole, scars, tattoos. Preferably mole, then tattoos, then scars. Okay, please do not mention scar at the very first go. If they have more, prefer mole. Medical legal examination report of sexual violence. That is, in case of the report continuing the same, that is relevant medical or surgical history. That is onset of menarche, whether the menarche has set or not, the cycle, what is the cycle, length, duration, last LMP, menstruation at the time of the incident, whether the person was menstruating or not. Many a times if the person is undergoing the cycle, we tend to dispose of the sanitary napkin. It has to be preserved. It has to be preserved. Whenever I say, once I had suggested somebody to air dry the clothes, okay, because it was wet. Okay? Air dry doesn't mean hanging in the sun. In the dark room, let's say this room, when it is not under use, isn't it? It has to be there on the floor. It should not be air dried, because after that the sample is not going to be fit for the test, right? Air dried. So, not air dried does not mean blow dryer, does not include ceiling fan. Just air dried, just leave it open. Menstruation at the time of examination. Was the survivor pregnant at the time of incident? Contraceptive use or not? Vaccination status, whether the person was given TT or not. Hepatitis B vaccination was done or not. History of sexual violence. Date of incident being reported, that is time of incident. Location, estimated duration, when was it? Because why this is helpful? Because many a time if the incident is old, isn't it? In such cases you are not going to find any findings, right? So the number of assailants, sex of the assailant, approximate age of the assailant, if known to the survivor, relationship with the survivor, description of the incident in the words of the narrator of the incident, whether the narrator was a survivor or the informant. In cases of small child, isn't it? Usually narrator is not the child but the parents or somebody, isn't it? Whatever, quote unquote. Whenever they say something, the history should be recorded in the language, in the words of the narrator, be it the child or be it the guardian of the child. Whatever the guardian wants to say, you can record it, isn't quote unquote, and whatever the child wants to say, the survivor wants to say, isn't that has to also be recorded, quote unquote. If I say I am a boy, although I am a girl, you have to write I am a boy, okay? Because that is what the narrator has said. Type of physical violence only if any described, whether it was hit with a hand, fist, blunt object, biting, kicking, pinching, pulling hair, violent shaking, banging of head, dragging, or any other. It has gone to the extent of describing the violence, to what extent and what it was, isn't it? Emotional abuse or violence, if any, like example, insulting, cursing, belittling, terrorizing, especially in cases of kids, isn't it? Why it is important? Because many a time the child is made to feel that way, that you are good for nothing, isn't it? Your worth is nothing when it comes to the world, right? So in such cases, if the victim says that it is my fault, the survivor says it is my fault, as a grown-up, as a doctor, as a law enforcement agency, you must consider the fact that it is the child that you are talking to. Maybe that person has been made to think that way for a very long time of period, so that's why he thinks that way, isn't it? So you need to be that beacon of light, isn't it, to give them hope. Then use of strings, if any, use or threaten the use of weapon or objects, if any, if there was any verbal threats, whatever the threat was, that has to be used. It could be blackmailing, using a photograph, phone call details, especially in young kids. It's like, you have sent me I love you, you have sent me I love you too, so I'll show this to your parents. That is usually the complaint, isn't it? So if those are also those things, isn't it, that also has to be mentioned why the victim went there. They could show that the victim came, or the survivor came on her own, isn't it, to the room. So she could be blackmailed or lured into coming there, isn't it? So that has to be mentioned very clearly, because when it is not recorded in the report, when it goes to the court, the same story, they consider the fact that the fact has changed now, right? But it was not changed, it was never highlighted. So if there is any other things that has to be mentioned, any history of drug or alcohol, intoxication, whether sleeping or unconscious at the time of incident, if survivor has left any marks of injury on assailants, then you have to enter the details. Let's say, for example, I had slapped the person, I had bit the patient, or I had scratched him, isn't it? All those injuries, if mentioned, has to be recorded. Then details regarding sexual violence. These are the things that has been included. Okay? What kind of penetration are we talking about? Whether there was emission or not, isn't it? If there was, what kind of manipulation or unnatural sexual offense that had taken place, isn't it? Everything has to be asked in detail, and considering this, your evidence preservation will highly depend on this. If there was no penetrative sex other than, let's say, something along the ways of exhibitionism, isn't it? So it's just like showing off the private parts. In such cases, do you think secondary victimization of the victim who has actually complained of doing this, preserving all these samples, is going to help? No, isn't it? It is not going to establish the fact, right? This is the entire thing. If there was condom used or not, if the lubricant was used or not, if they can find the company, that would be great, because if they can find the control, they can rule out that. Having been said that, if a spermatozoa is discovered, then in such cases, it is established fact that there was a sexual assault, right? And this needs to be mentioned. If there was changed clothes or not, whether the undergarments was changed or not, whether the person has taken bath or not, passed urine or not, and rinsing of mouth, brushing and vomiting, because there will be injuries. Sometimes there might not be even signs of struggle, there might not be even genital injuries, isn't it? And spermatozoa might also be negative. So in such cases, could be different reasons, isn't it? The person could have been drugged, could have been unconscious, isn't it? The third person is in the third case, and the person could have undergone. She didn't know that she was assaulted, isn't it? She took bath probably, isn't it? Later on, when she found out, she could have come, isn't it? So if there is lack of evidence, the report has to have an explanation why there is lack of evidence. That is what our sir was also trying to say, isn't it? That if there is lack of evidence, isn't it? And if you say that there was a crime, okay, there was an assault, okay, if the report says this could be the reason, if you can derive the fact that this could be the reason why the evidence is not there, so in such cases, the burden of proof for saying that the person is not guilty as charged, isn't it, lies on the accused. Whereas the other way around, the victim has to prove it, right? So proving is, this is the proof that we are trying to look for. So make sure that you give it 100%, right?
Excuse me. Many a times, sometimes underage marriage people, they also come. So, ma'am, so how do we create a report? Because it will be always consensual. So, like, how do we create a report?
That I would like to ask our sir's opinion. So what do you think? What is your opinion? Because I have my opinion both ways. Okay? So whatever the society is right now, I'm only knowledgeable. Okay? I'm not a police officer. I don't go practice one. What society is heading to? If you can tell me, give a gist. What is the society heading towards? I can explain you why, how, and when.
So he is coming with his own set of experiences which he has experienced in the past 6 months. And so generally what happens is there is a underage marriage where the survivor is underage. And there have been instances where both husband and wife are also underage. So now what happens is, when the survivor gets pregnant, when she comes for a institutional delivery, so as per the law, the hospital sends a call book intimation. Saying a pregnant lady
Who is a minor.
Yeah, who is a minor. So now the legal process initiates. So as per the laid-down guidelines, if it is a minor, we have to register a case as per the relevant sections, and we go with it. Now here it is a scenario where it is very difficult to go in one way itself, because if you arrest the accused, then the survivor is alone to take care of herself and of the unborn child. It's generally 8 months or 9 months term pregnancy. But also, as per to upheld the law, we register a case. Now, I don't think so anything will be available over here apart from the previous history, whether these things were used, not used. That thing. So in the end, what we do to prove the paternity, yes, the accused is the person who had a sexual relationship with the victim is when the child is born. So when the child is born, child's blood, maternal blood, accused blood, 3 of them are collected and sent for RMSL. And if the survivor opts for a MTP, which is also there in the provision, then the sample from the product of conception, the accused blood and the survivor's blood, 3 of them are collected and we send it to the RMSL just to prove the paternity. But in most of the cases, such cases turn up into acquittals.
What?
Why? I'll give you an instance. The victim, when she gives her deposition and all, so she says, no, I haven't been forced, I haven't been coerced, I haven't been influenced, I haven't been drugged. I know him, he's my boyfriend for past 5 years, we were in a relationship. So the onus of the police or the investigating agency lies in the POCSO cases is to prove the age first of the survivor, saying that this survivor is a minor. Now, proving the age, there are certain guidelines, age proof. Now, the second part, whether a sexual offense has taken place or not, that is the most important aspect, which we, in what he has told, we do it like this. So, not going into society and all, this is what we do as an investigating agency, because we don't have any other option. We have to register a case, we have to charge sheet it, and if there is an acquittal,
You're bound by law to do
yeah,
that.
we are bound by law. And if there is an acquittal, the IO gets a post-mortem by the supervisory officers, leading to memos, warning letters, and in future and in past, some of the IOs are even suspended with the financial implication on their salaries. So the IOs, when they write the case for a POCSO or any sexual assault cases, they have to take into consideration various aspects, especially the medico-legal aspect. Actually, this training was for the investigating officers, but me having on the middle path, on both sides, I was sent.
The path less chosen.
Yes, the path less chosen. Okay, so why I am telling this is in my district, I had already conducted one workshop with the medical officers 2 months back with my IOs. Now, why this is there? All over the state, the IOs are over here. So, there are many discrepancies of how a district functions. My district functions in a different way, Tenkin's district functions in a different way, and there are separate things what we do. But in such cases, this is the practice what we do. This is for the consumption of the house. In such cases, you won't get any evidence over here. You can just fill up the history. But to prove it, we go for that. We wait for 9 months, take permission from the court, get the blood of the accused, get the blood of the newborn child, get the blood of the survivor, send them for DNA estimation, provided the process of collection of blood and chain of custody is maintained. We have been having cases where accused is acquitted even though the DNA is matched. But the process of collection of samples and the chain of custody was not proven. So the accused got acquitted.
What is your reservations? The victim has come, they are married, and they come to you for examination. What is your issue with it?
For filling up the format, if all the individuals are not making sure, so we should say that it's not there.
Do they have chalk and talk? Do we have blackboard? No.
Ma'am, actually, what I'm trying to say is that if they are having consensual relationship, but they are engaged, so we get the format, so filling up all these formats. So what I'm trying to say is that we have to mention it as it is, that no injuries or whatever.
I understood your questions. It can fall both ways. Okay? As law enforcement agency, they are bound by law to take action, isn't it? You, as a doctor, as a rule, if you act professionally, they came to you, you are supposed to examine, isn't it? That should be it, isn't it? But obviously the human aspect of it comes into play, isn't it? If we are going that way, what I'm trying to tell you, what will I tell you is, let's say, the first thing in the report is what? Consent, right? So, if the person gets ticked for examination and the treatment, isn't it? Rest, she refuses, isn't it? Everything has been explained to him, isn't it? Refuse it, isn't it? If you skip one point of this whole paper, no, then you are going to be so that is where the I think problem lies. If the person refuses to give the consent for examination, there is no evidence, there is no examination, isn't it? On top of that, you take it in writing that she refuses to give the consent and everything, isn't it? Although it is POXO. Although it is POXO, so the law will take its course, isn't it? So it does not matter whether the patient has given the consent or not, even if they are husband and wife. It is a statutory law stating that even if they are husband and wife, if there is an intercourse, then it is considered to be a rape. Because that is the whole definition of it. But if you go to the court with the same definition, if you go to the court will ask the victim, isn't it? Was this the person who has caused the sexual assault? If she says no, isn't it? Then it is acquittal, right? But if you are trying to tell me that you are the judge of things, then no. Why? Because 10 cases, the same thing might happen, but one of these cases might be forced into marriage. Getting my point? In order to not miss that case, we are playing into all this 10. How we are just a block in the system, right? So if we play our own part, if the person has come for examination, you take the consent, the person has refused to give the consent, isn't it? You do what is needed, no examination taken, no examination done, and no evidence taken, isn't it? Because the person has refused it. The same goes for you also, isn't it? You are going to say that the person has refused to give all the samples, isn't it? You are going to put up with the court. I think the survivor will be taken in front of the magistrate. If the magistrate says that no, this was I'm like we don't have any relationship, this is my own kid or something like that, isn't it? Then in such cases, if the victim refused to accuse someone, isn't it? There has to be an identity and there has to be a crime, isn't it? If the victim says मेरे पे कोई offense ही नहीं हुआ है, then we cannot say that no, you are the victim, right? Even the court cannot do that because that is a constitutional right, isn't it? So for that case, even the court makes an exemption. Not only that, I believe it was in Chhattisgarh. There were so many pending cases, isn't it? So many of these cases were such because being the tribal region, many in bulk the case was disposed of, saying that if it was consensual, forget it, dispose it off, everyone was acquitted because many a times they are the only sole breadwinners of the family. That was the main problem. But if you are asking me, can I do that? Like, oh, they are saying that there is no complaint. You are nobody to do that. Okay, because if you are saying that, okay, since both are known to each other and they are married, so I am not going to lodge a complaint, then there is a big fail in your part if you are not doing that, right? Same goes for the post-mortem examination. So many RTA cases that has been sent for police intimation to the Sardar Thana Ranipur police station, isn't it? But the police officer come to the place and say that post-mortem is not required, even though in NCCD form it is mentioned that the cause of death is to be determined after the post-mortem examination. The body has not reached the morgue, and I wonder why. This is the second time that I will be filing a complaint. But please look into it. I'm a biggest fan. I'm not a biggest fan on punishment being deterrent for everyone. Okay? I believe in taking second chances. I believe in training, correcting. But even after 1,000 times of training, if you are not going to understand things, then I think you are being difficult, right? So once again, I'm going to try. Once again, I'm going to put up the complaint. Let's see what comes out of it. So there are some blocks which is wrongly placed, isn't it? We can work around it. If it doesn't work, what we can do, isn't it? It's up to you. If the biggest solution that I can come up with is this. Many a times I have heard biggest law enforcement agency also people talking that there are family members who comes to us requesting not to file the complaint because that is going to ruin his or her career, isn't it? Then in such cases we do feel the pity, isn't it? But is it up to us? Because it is not a compoundable offence, isn't it? POXO, because everyone who is under 18 years of age, they are vulnerable age group, isn't it? Why we are not allowed to do that? Because this can be a genuine case. Maybe you have let go of 2 genuine cases, which was same sort, isn't it? You let go of it. The police officer also said, let's not take up this case. Okay? So both the people, they let go of it. Okay? Now what happens? The third genuine case, which was an offence, okay, comes to you, they will try to buy the parents out or try to bribe them in some way or the other, isn't it? And in such cases, such survivor or such minors, isn't it, will undergo through all this pain. And the worst part is, if such is an cover-up, isn't it, they won't be given the psychological support, the medical attention that is needed for them, isn't it? So in order to avoid that, we are going through all this pain, right? So I think you should complain We can always be sympathetic towards the parents, isn't it? Sympathetic in the sense like you do have police, community policing, isn't it? You do that. So you go to the community, make them aware of this laws, isn't it? If the person is less than 18, even if you guys are married, isn't it? It is considered to be an offense. Both for male and like 375 is mainly for female, isn't it? But POCSO is gender neutral, right? So it can be both the way around. So one has to take precaution in the sense, I think health education along with good touch, bad touch, a little bit information about the law is good for them, isn't it? If you know that at 18 I have the right to vote, this also at 18, until 18 I am not supposed to have any sexual act, should also do them good, right? I think that is the one solution that I can come up with. And we have reached here. Now, the time since incident, isn't it? How much time has passed? This will cover everything, from the GD entry to everything. This will cover everything. That's why it is beautifully designed. Everything will be in this. If you don't skip any of this line, no, there is nobody that can question you. History of any discharges, isn't it? Or prior to the incident of sexual violence. If there is so, like for example, if the person is going through cycle, that has to be mentioned there. If there is painful urination, everything has to be there. General physical examination, the vitals has to be recorded along with the general physical examination of the survivor. Please focus on writing the mental status of the victim, because at some times what happens is the victim might be, the survivor might be in a state of shock. They might not be able to recollect everything and tell you in words what had actually happened and what they had undergone, isn't it? In such cases, what you are going to do? You are going to describe the mental state of that person. The person is in shock, silent, isn't it? Reclusive. Those are the vocabulary also, but describing the mental status also of that person, isn't it? If you state that, later on if she recollects everything, isn't it? And she says something else, you can say that the person was in a state of shock and could not tell the history properly. So that means that whatever she is saying now is the truth, because you established that in the first record, isn't it? Oh. So examination of injuries on the body, if any, the pattern of injuries sustained during an incident of sexual violence may show considerable variation, whether there was absence of injuries or it was grievous. Injuries of all sort has to be mentioned, be it boils, lesions, hypopigmented marks, scars, isn't it? If it is, please do not mention scars. First of all, do not mention scars. If you think it is of importance, then mention it is an old wound. Okay, not relevant to the case. Okay, because then the defense will try and hackle you, saying that like ये scar जो है उसी time में ये incident भी हुआ था and things like that. Okay, so do not mention old injuries. Try and avoid it unless you feel that it has some importance to the case.
One more thing, ma'am, during inquiring about all the examination part, sometimes the survivor also mentions like previous assault by some other people. So during that time, should we mention the name?
Everything has to be mentioned, and in the order that the victim has mentioned, everything has to be mentioned. Why? Why? Because there are chances that this is not the first time that it has happened. The accused can be the same person, and during that time the victim could have been minor. Okay, so it leads to many things, isn't it? So verbatim, the exact word of it has to be recorded in the history. We will be talking about how to age the injury, isn't it? Apart from that, size, type, shape, color, swelling, isn't it? Whether it was simple or grievous has to be mentioned. Usually when we write for sexual offences, isn't it, we forget to mention the thing that we do for the injury report. That also has to be done here, because be it in the sexual offence, an injury is an injury and has to be treated in the same way and order, isn't it? Injury, like whatever is the injury that is sustained, isn't it? Like say scalp may have a lacerated wound of 2 into 5 centimeter, whatever is the centimeter, isn't it, on the, let's say, parietal eminence, on the right parietal eminence of this dimension surrounded by the contusion, whatever it is, isn't it? But you have to mention that. In the same way, you are going to describe all the injuries, so that you don't miss out on any of the injuries. All these parts has also been mentioned here. And if there's any other areas that has been specific, isn't it, that also can be read. Let's say the nails have been extracted or something of that sort, isn't it, can also be written out there. Do you think hair injury is an injury? It is of importance. Why, I'll tell you. Because the victim might say the person had pulled my hair, isn't it? Or in the struggle, my hair was removed from the scalp, isn't it? If the hair is found at the place of occurrence, isn't it? That is also a locus principle of exchange. Locus principle of exchange is a triad, isn't it? The victim, the accused, and the POC, place of occurrence, isn't it? So everything and anything that she mentions is of importance. Okay? And please ask them also, like where do you think you are hurt? Like where is it hurting, isn't it? So this is the area that you have to mark it. Like for example, we have mentioned injury abrasion 1, 2, 3, 4, 5, 6, whatever it is. So 1, 2, 3, 4, 5, 6, wherever it is, the injury has to be mentioned. Local examination of genital parts or other orifice. These are the injuries that has to be mentioned. Now, this was what I was trying to tell you. Like for example, two-finger test, isn't it? Why it is banned? Although two-finger test, when you say that, isn't it? The whole structure is there. If there was a blackboard, I could have drawn and shown you. But if this is the uterus, isn't it? The mouth is the cervix, isn't it? And then there is a passage that is the vaginal orifice. This is what it is. Now, two-finger test, where are you doing? The fact that two-finger test should be done at the cervix, and in emergency you don't have a speculum. So what are you doing it for? If you are not using the speculum, you are not reaching the cervix. So what is this two-finger test that you are doing? I don't get it. Getting my point? It can be done once it is open. So if there is a forceps, then only you can see it. If there is no forceps, how you are doing it? And I guarantee you, if it is a recent sexual assault injury, no victim will permit you to do that. Because it's a stabbing pain that you undergo, isn't it? So, in such cases, avoid doing that. That's why we say it, isn't it? There are other forceps also that can be used, although it is said that it can be used, it has to be used with LA, local anesthesia, so that the patient feels less pain. Okay? And I think it is inhuman to make the person undergo through that pain again, just for the heck of preserving the evidence and for your satisfaction, right? Everything else can be done, isn't it? Urethral meatus and vestibule, isn't it? Urethra, everybody knows about the orifice there is and the opening in the males, isn't it? The labia major and minora, the covering of it. Fourchette is at the back of it and hymenal perineum, isn't it? It is said that in the court it has been debated by the NGOs, many other parties also, isn't it? Hymenal tear itself cannot be the sign for sexual assault or not a sign for sexual assault, because there are other injuries also that can cause hymenal injury, isn't it? So that itself cannot be the evidence, is an established fact, right? So that is why two-finger test was also not done. Okay, so basically in two-finger test in forensic, it was said that it was done for hymenal opening, to see the hymenal opening. Okay, but if you know the different types of hymen, isn't it? There is an annulus or a notch, isn't it? Which is common. So many inexperienced eyes tends to record that as an injury at 12 o'clock, 3 o'clock or whatever it is. It is not an injury. It is a normal phenomenon which you have caused to be now an injury, isn't it? When I say injury, isn't it? I can teach you in 5 minutes what you are looking for. You ask the person to be in a lithotomy position, isn't it? And you are examining if there is any injury, abrasion, contusion, scar, laceration, everything and anything that is there has to be examined, recorded, right? Now, first thing that you are going to do is collect the sample, whatever is there, preferably a swab. Okay, make the smear, make two slides. Okay, so that one you can see it under the slide. If there is any spermatozoa, you are confident if there is any spermatozoa, isn't it? I prefer 3. 1, I keep it for myself. 2, I would like to give it to the police officers so that I know if there is any misplacement of the slides or if the report is coming negative. I can always put that up in the court that I have done the examination, I have the slide with me and this was the case. Okay, they can do the examination later also. I'd like to keep 1 for myself and 2 I'd like to send. Okay, if it is my case, usually right now we don't do those cases. Medical officers does that in Manipal, so 2 slides, prepare it, isn't it? The swab, preserve it, okay, and then take the gauge, do the wash, put the kidney tray underneath, and then do the wash, take the gauge, isn't it? And wash it. First, try to wrinkle it, the water, normal saline, not the water, sorry, normal saline, and then air dry it. air dry. Okay? And then once you have done that, sample has been preserved. The sample swab, it is said that you have to take two swabs, one from the higher up and one from the low. Low, they mean the upper end of the cervix or the upper end of the vaginal orifice. Okay? And the second swab that we are talking about is through the opening, urethral opening. Okay? Not urethral opening, uterus opening, cervical opening. Okay? So the second sample, we are supposed to take it from there, so that we know she is going to be impregnated. Right? So if she is in the ovulating phase, so that sample has to be taken. Those are the two samples that has to be taken, high and low. Okay? And the wash, whatever wash that comes, that also has to be preserved. These are the samples that are, apart from pubic hair, and then the other samples that you are going to take axillary hair, if there is any signs of struggle, nail clippings, nail scrapings, blood sample, scalp hair, all those are the other samples that are taken on local examination, isn't it? You are just going to examination. If the patient is not that comfortable, ask the patient to cough, put them in the longitudinal position and cough. Once the person coughs, isn't it, you will get a good view, isn't it? You can see the hymen there. The importance of our finding is not the fact that you say it is 2 o'clock, 3 o'clock, 6 o'clock. It is not that. It is to say whether there was fresh bleeding or not, whether it is red, brown, black or scab formation, whether there was swelling or not, edema or not, isn't it? Whether there was any discharge or not. And if there was a discharge, what was the color? That is the actual finding the court is actually looking for. Many times even the people are inexperienced in the court, but if you go and highlight the fact that I can say for sure that this is the fresh injury based on my this findings, right? Nobody can argue it. Okay, so what you are saying and what you are writing should be at the end of what you want to say. This is just the process of what you want to say. Getting it? So that is what is of importance. So doing 2-finger test or 3-finger test or 10-finger test is not going to give you any good, isn't it? Because it's not going to say whether it is recent or not. And many a times your seniors also might write this habitual sex or something, engaging in sex or something like that. Okay? Please do not comment on words like that, because court, I don't know about here, but then Supreme Court takes it very sternly. If you use such words, you are not supposed to comment on the sexual history of the victim, isn't it? Whether the person smokes, drinks, wears whatever, Western, Eastern, isn't it? Stays in a nuclear family or the joint family, isn't it? All these things are prejudices against the victim. It is like victimization again for the second time, isn't it? So please do not have those in your reports. Be scientific, as I'm forgetting the Borderly, I think he has said once, isn't it? If law has made you an expert witness, isn't it? You have no victim to fight for, isn't it? You have no accused to punish for, isn't it? You are a man of science, isn't it? So be the man of science when the law calls for you as an expert witness. Take it.
Here I want to add, this is for benefit of both the IOs as well as the medical officers. So when you give positive finding in your local examination, the IOs also listen to it. Many of your cases are acquitted on these grounds. So when the doctor gives a positive findings in his or her examination of the local examination, so in a way it proves that there was a forceful or a sexual offense was taken place. Now, when you depose in the court, especially the doctors depose in the court, the defense will ask, Dr. Saab, यो जे साइन्स एन्ड सिम्पटम्स तपाईले लेख्नु भएको छ तपाईको एमएलसी मा हो, यो त युटीआई मा पनि त हुन सक्छ, सर्भिसाइटिसमा पनि त हुन सक्छ, then you don't have any answer. You say yes, हुन सक्छ. Okay, that my IOs listen carefully. That is your nail in the coffin of your case. That means your sexual offense is not proved. Many cases have been acquitted. So, to get out of it and to be on the safer side, the IOs, I have advised my IOs, you should tell to your SPs, कि when you give a requisition or when you are there when the local examination going on, urine test पनि गरिदिनुस् Dr. Saab, UTI exemption को लागि. Okay, then in the court also you can say no कि हामीले UTI को लागि त urine test गरेको, SPF मा केही देखेन, pulses देखेन, so UTI is ruled out. But if you don't do it, the medical officers, you will be in a spot in the deposition, and our IOs, they will lose their case. So this is a retrospective view which I found out when I go through the judgment order of the acquittals. So whenever an acquittal takes place, the district SP has to go through the acquittal judgment and give his or her opinion whether a action is initiated as per the lack of investigation done by the IOs or not. So this was in some of the judgments where the defense just picked up a thing, whether such kind of symptoms can be due to some UTI, cervicitis, anything or not. So it can happen due to a UTI. There can be rashes, there can be burning micturition, there can be pain. So just to be on the safer side, the IO specially, you should mention in your medical MLC form or requisition the rule of UTI.
Like I say, when you go to the court, a night before, stop watching Netflix, okay? Take your common sense. You have enough knowledge with you, okay? But you need to gather your mental ability to think and think sharp and smart, okay? So stop watching Netflix. If you want to listen to the music, and sleep off, okay? Wake up in the morning, okay? And then when you go to the court, collect your thoughts first, okay? Before saying anything. If somebody says that the person was already suffering from UTI, isn't it? You say yes, and then you volunteer a statement saying that, ma'am, I would like to volunteer a statement saying that although UTI could have led to the signs and symptoms, but the sexual assault itself can also lead to the UTI. Okay? So you need to have the presence of mind. You can only fight for a case. Please remember that. So whenever you go to the court, people can walk in casually also. Okay? But take the longest breath of your life, because take the onus on you. That is, it is up to you to fight for someone, isn't it? So when you take that credibility and accountability on you, and I think you will come with a better statement when put up to you by the defense, right? So these are also the burning situation and things. So if you know this is it, isn't it? You know, whenever the defense asks you the question, no, first question, that is not the real answer that he is looking for. The third question is the question that he actually wants you to answer. Okay? So he is just building the premise to lead you to the third question. So whenever he is asking you the question, please think of it. What is going to? Okay? Then if you don't understand, if you are not able to guess it, like where he is going to, ask him to reframe the question. I'm not able to understand. Could you please reframe your question? Ask him to reframe the question until the point you understand. And this new thing has happened, isn't it? Nowadays they come up with the research articles. They have come to you with one. Yes, research papers. They come up with one. Books, everything. Ask them for the references. Ask them what is the reference. If they don't give you, ask for the paper one. Read it through. The hint. Okay? The same study participants or the sample might not be the same as the case right now. First is that. Second is go for the method and material. It is not the same as this. Okay? And third, directly jump into the conclusion. Conclusion, whatever it says, he is trying to prove that. Okay? So in any other way, like for example, I'll give you an example. One case, there was a case of medical negligence. So they tried to prove that it was the COVID that had led to the starvation and the death of the household. Okay? So it was not only that. So he was again and again trying to prove that it was COVID. Then I said, like, if this was COVID case, then I would be wearing a PP. I would be diagnosed with COVID, isn't it? Not once I was diagnosed with COVID. So this was not the case of COVID, isn't it? And besides, so he went on to finding that since it is written in the research paper, he argued and fought with me in the court saying that he wants to establish the fact that COVID had led to the starvation. Then I volunteered the statement saying that yes, COVID can lead to the starvation, provided if it is a neglect from the person who is taking care of the child, because she was a minor, right? So unless you give them back, they will come back to you. Okay? And what else? Here? Where will he? He's somewhere here, isn't it? And if you can see, it includes both, isn't it? Because it could be the third gender also, isn't it? Or any other. It is gender neutral in cases of POXO cases. Okay? So, a medical legal examination. So all the findings that you have seen, you are going to record it here, isn't it? Although it is a sample that has to be taken if there is a forceful penetration. It is also advised to take the anal swab also in all the cases. Many a times it is said that it gets accumulated there, isn't it? The sample. So please take the sample. Or oral cavity also, whatever it is, you have to mention there, isn't it? If it is a child, if there is any bleeding of any sorts, isn't it? And systemic examination, serious CNS, respiratory, chest, abdomen, isn't it? Sample collection or investigation for hospital laboratory or clinical laboratory. There are two samples that not more, it's going to be more than two, but the samples that you are going to send, one for HIV, VDRL and HBS antigen, the second is urine test for pregnancy, the third is ultrasound for pregnancy and internal injury, X-ray for injury, one more, that is blood grouping also you are going to send it for. Take sample collections for Central or State Forensic Science Laboratory, that is debris collection paper, where actually there should be a white paper spread on the floor so that the person is, and please be very cautious of the word that you use, not so much here in Sikkim, but if you are practicing outside, do not ask the person to get naked. Okay, please tell them to undress themselves and hand the change, whatever the change that they are going to do that beforehand. Okay, otherwise that will also be taken in the court saying that the doctor asked me to get naked, that's why I refused everything. Okay, so please be very careful when you use your words, you know. Think twice before you are saying something, you know. And whatever it is, if you are not comfortable, isn't it? If you think that your voice is loud, the same person saying the same, the two different persons saying the same thing, isn't it? Might sound so different. Somewhat they are loud, the bass is very loud, isn't it? So even if they are saying it with love, it sounds wrong. Okay. So if you are of that personality, the attendant who is there with you, isn't it, ask the person to do the same, isn't it, and train them not to beat the patient like, "Jaldi karo, kya hai, kyun itna der kar rahe?" Don't ask them to be sympathetic. That's why they will say well skilled, isn't it, and trained and being sympathetic towards the survivor. Debris collection paper, clothing evidence were available to be packed in separate bags after air drying it. List and details of clothing worn by survivor at the time of incident of sexual. Oh, having said that, the white paper is spread. She is going to undress it. Whatever it is there, isn't it? It is to be collected in that paper itself. So, if not the accused, could be the sample could be there, isn't it? Seminal sample could be there. Seminal fluid could be there. Spermatozoa could be there, isn't it? Even if it is not there, mud, dust, whatever the particles are there, isn't it? If it is similar to that of the place of occurrence, it is established fact that she is not lying, right? The incident had occurred. So, body evidence or sample as appropriate, duly labeled and packed separately. Swab from stains of the blood, that is blood, semen, foreign materials, others, scalp hair, 10 to 15 strands. When I say scalp hair, is it plucked or is it cut? It is cut. If the patient is alive, okay? Usually, in all the book it is written as plucked. So we used to do plucked only, okay? But it is cut. The Supreme Court has said that which has to be cut, right? So, head, hair combing, nail scrapings, both hands separately in separate samples. Okay? Nail clippings, both hands separately. Oral swab. If you are doing oral swab, isn't it? Please ask for the FTA card from the police. So police can collect it from the FSL lab wherever they want to send it, along with the form that the doctors are supposed to fill. Then blood for group oral swab, that is for the DNA. Blood for grouping, testing, drug and alcohol intoxication, plain white, and one in sodium fluoride, and EDTA vial for DNA analysis. Urine for drug testing and any other if there is any of the following objects present. Okay, that has to be preserved. If any of these samples you are not able to preserve, that also has to be mentioned. Many of the reports from the PHC that I have seen, few of them, not many, few of them I have seen, they have said that they did not preserve the sample because the person was having their cycle. Even if the person was having a cycle, you are supposed to collect the evidence, isn't it? Because it is not going to stay there after that. In fact, if the person was undergoing a cycle, because of the napkins used and everything, isn't it? The sample is there with that person, isn't it? So it is even more effective in such cases. So that has to be preserved. If you are not preserving, then you have to mention the reason why. For example, nail scrapings you might get, isn't it? Sometimes the nails are not that long enough to get the nail clipping itself. So nail clipping not long enough, isn't it? But nail scraping is collected, isn't it?
Apart from EDTA vial, can we collect blood for DNA analysis in any other medium?
Yes, the filter paper that is given, isn't it? That has to be collected, but the thing is, like for example, I studied from SCB Medical College, that is Oria's highest college, okay? So we can do whatever we want to, okay? So it is like free hand to us. We can send, that becomes the rule, okay? So we used to use filter paper, dab it along with the gauze also. Gauze also has to be stained with blood, isn't it? Crush it, air dry it, and then send both. Filter paper and gauze piece soaked with blood, okay? That has to be sent. Filter paper, you are taking the blood through syringe, isn't it? Then you blot it. Once is tapping, the second one is blotting. Okay, that is, those are the two samples that has to be taken. But if you want to send it to Delhi, Hyderabad, Chandigarh, isn't it? They have their own taking of the samples. Okay, they accept samples only in their FDA card. They have their own FDA card. They only accept that. But if you have an MOU with them, if you can build an MOU, the director is very nice, isn't it? You can go talk to him, if you can suggest us a coordinator, and you can have a good inflow and outflow of information, that would be great, isn't it?
Why I'm saying EDTA card, the reservation
Yes.
is not, we cannot manage the reservation.
See, we don't have a safe kit, we said, isn't it? Safe kit has so many things, so many envelopes, so many labeling, so many samples to be there. We are doing it. Hai. So I think one cooler. Do you remember the PHC, the ASHA people, they come no, with the cooler? That with the ice pack is more than good enough, 4 degrees Celsius to maintain it. Or a thermometer chipka, then if they argue so much, like they could have 4 degrees. So we maintain that.
आयुषहरूले के गर्दैछ यसमा भन तिमीहरू यो वर्कसप यसका लागि त भन त के गर्दैछ तिमीहरू
ब्लड स्याम्पल लागि सर फिल्टर
पेपरमा गर्दैछ हैन
इडिटी भए त उता मान्दैन नि सर इडिटी भए त असल मान्दैन नि सर
कसले चाहिँ मान्छ
सिएफएसएल मान्दैन नि सर प्रिजर्भ गरेर पठायो भने टाइम फ्रेम हुन्छ सर
सिएफएसएल कि आरएफएसएल
सिएफएसएल मान्दैन सिएफएसएल
it will take somewhere around 15
Chandigarh
15 to 20 days to reach that file to the RFSL lab.
असम से पॉजिटिव आया है कुछ रिजल्ट तो वही
Also, I think
unless you ask them for the FTA card, no, FTA card money, no. Actually, it is like copyright patented also, no? So you cannot copy that exact absorbent that was used in that FTA card. You cannot copy it. Okay, so they have this absorbent which once the blood is kept there, isn't, and you put it in an envelope, it is not going to get contaminated. It is not going to get this thing, fungi and all won't grow, bacteria won't grow in it. So that is the FTA card that has to be sent.
FTA card full form.
Let me check.
C or G
FTA.
That's why we go by the filter paper.
No, I'm surprised they are even accepting again. Because EDTA blood vial, that is the, this is actually questionable to the lab also, no? The state also should file an RTA asking you, like, if, let's say, no, you want to do a retest over the sample, let's say after 9 months the child is born and you want to recheck it, isn't it? So what you are doing it? Because EDTA vial, that's why it is important. Why they are not taking an EDTA vial is also one thing, because if you take the EDTA vial, they have to preserve it for 15 years. They cannot discard it until 15 years, so they don't want to pile it. Okay? So one reason is that, for example, viscera, when you preserve, it has to be in a glass jar, isn't it? But they don't know where to throw this glass jar. There are so many, so they ask us in plastic jars, so it's easy to burn them, isn't it? Disposal is the main problem with the FSL labs.
So,
What is the full form?
Fast technology for analysis. Okay.
So every lab has a specific FTA card.
And it is mentioned that whatever lab that you want to send, the police is supposed to inform them and get it. Like for example, Delhi and all, it's convenient, isn't it? We don't have it, so if we have an MOU and a coordinator is there, like if you send us 10, then we are going to send you the same 10 sample and not like misuse it. Maybe we can work around that. Why I am saying filter paper? No, they say filter paper में ना ऐसा होता है Whatman number. Actually it's a Whatman filter paper है ना, वो number होता है 4321, depends on the porosity of the filter paper, isn't it? So what filter paper you are using, I might not be using the same, isn't it? Filter paper actually was done to see the, let's say, urine test करना है, albumin, globulin, ऐसे protein का करना है. What we used to do is, remember in the lab, उसको funnel के ऊपर रख के, then we used to filter it and used to trickle down. Okay, it trickles down eventually, isn't it? Leaving it a kind of proteinous substance on the filter paper, isn't it? Now what man paper it is used, isn't it? Till date, it is not mentioned. So I might be using non-porous. You might be using porous, isn't it? So if you have wondered, isn't it, the filter paper that they use, it usually dries up very quickly. FTA card also, it dries up very quickly. The filter paper that we use, it does not dry, it blocks, right? We are using non-porous one. They are using porous one, and they don't say it because they have copyright to it. Because उनको भी तो अपना दुकान चलाना है ना, ठीक है? So, and yes, the preservation has to be at the 4 degrees Celsius, as I've said, isn't it? The sample that needs to be preserved, isn't it? As a doctor, these are the samples and evidences that needs to be preserved and sent. So the samples that are being preserved has to be properly packed, sealed, labeled and separated to be placed in a bag. It has to be, the swab sticks for collecting should be moistened with distilled water, and then the swab has to be collected. That is for vulval swab, vaginal swab, anal swab. All these are different swabs, okay, that we are talking about. When we say two, isn't it? One is from the lower, one is from the other one is from the higher. Cutting of pubic hair combing. Why the difference? The combing of pubic hair is because if there is any foreign pubic hair from the accused, isn't that can be collected, and if it is collected while combing, you have to mention that separately, so that that hair is compared with the victim and with the accused also, isn't it? So that would be great help. Then cutting of the pubic hair, then matted pubic hair. Usually, what examiner, what as a even when we were as an intern, our senior used to do that, isn't it? If you are examining, isn't it? If something is moist, isn't it? You try and avoid that area, considering it to be dirty, right? But that is a sample that is actually needs to be preserved. So cut that sample, preserve it in the paper, the soil paper, isn't it? And then vaginal smear that has to be prepared, preferably 2 in number. It has to be air dried. Smear whenever you prepare it, isn't it? Just leave it here. This is the room for examination, leave it here. Do not switch on the fan, do not switch on the blower, do not keep it in the sunlight, just there. Air dry it. Urethral swab and then swab from glands of anus or clitoris. Then medical legal examination of report of sexual violence report. When you come to the final opinion, the first opinion that you are going to form is known as the provisional opinion. Okay? That is not the final opinion that you are going to form. I will help you in forming the opinion today. Okay? That is this should be the content. Okay? So I have examined the name of the survivor, the male or female or any other, age, reporting, type of sexual offense that we are going to discuss it later, and then days or hours after the incident. How many hours or how many days have passed by after having bath or not having the bath. Okay? My findings are as follows. Then samples collected, clinical findings, and then additional observations, if any. If the patient was intoxicated or any of that sort, isn't it? Or if the patient is physical disabled or like unable to hear, isn't it? Mute in any ways, isn't it? That also has to be mentioned here. Clinical findings, let's say in the same case as the sir said, isn't it? If the person is suffering from Bhutia, isn't it? That has to be mentioned here. If there is any findings prior to the examination, there was also one line in the previous report, if you have seen it earlier, isn't it? If there is any other illnesses in the past, isn't it? Before the incident, that also was supposed to be mentioned there in the report, isn't it? That also has to be mentioned here. Treatment protocol, if this was the treatment given or not. Let's say the patient was in the situation, let's say 3 months back. Do you think emergency contraceptive is going to help now? Let's say the incident took yesterday. Do you think the urine pregnancy test is going to help now? No, isn't it? So make sense, use the resources, take value of it and use this wisely, isn't it? Because if the incident happened within 24 to 48 or within a week also, isn't it? It's not going to show any positive result, isn't it? So make sure that you don't do unnecessary testing. Date and time and completion of examination, and please do not forget to mention what are the number of sheets that was involved, isn't it? And how many envelopes you are sending along with it. The signature, name, seal and the place where it was examined. This is the provisional report along with the treatment that was advised. Then comes your final opinion. Final opinion is when all the reports that you have sent to the lab has come back to you. Okay? The police officer, the investigating officer will contact you and you are going to make the final opinion. Findings in support of the above opinion, taking into account the history, clinical examination findings and laboratory reports of dash-based identification marks described above, dash hours or days after the incident of sexual violence, I am of the opinion that what is that part I am going to explain it. Okay, what will happen, what is the situation, what is the finding, and based on that how you are going to form the opinion. Okay, it should not come up from the air. Okay, I feel like writing this today. Okay, I am feeling very lazy. That is not how the opinion is formed. Okay, it is a same line, exact line that you are supposed to write. If you are not comfortable with the idea of remembering it, it's okay. Okay, paste it on your wall. Emergency wall, paste it in your wall. You know what to write when what happens, isn't it? Then, copy of the entire medical reports must be given to the survivor or the victim free of cost immediately. That's why there is 3 copies that has to be written. One, you are going to keep it with yourself. The original, you are going to send it to the investigating officer. Original, you are going to send it to the investigating officer. The first copy of it, you are going to keep it with yourself. The third copy, you are going to give it to the victim. Are you typing it or are you writing it in carbon copy? Carbon copy. I would encourage you to write it in reporting, because Supreme Court on many occasions has said that MSc reports could not be read easily. Please type it करके ना. So if you can write the report, especially of the sexual assault, do you have computer in your PHCs and district hospitals? You do have one. So you have a printer. So take your pen drive with you, isn't it? Always have a copy of whatever you write in the for the court, or you are going to be called up in the future for, isn't it? And also to go back and see like how vastly the society has changed in reporting wise, isn't it? How you have been progressing, isn't it? Just to analyze for yourself, also to be not to be self-critical, but you need to know, isn't it, whether you are progressing in your life or not. So in order to analyze that, keep that record with you, okay? And you know where you have gone wrong, isn't it? So you won't make that mistake again. So do that, keep the record, right? The format will be there. If you want this format, you can ask one of your clerical staff, isn't it, to type this format. Or this is a PDF form that I have forwarded to you, so take that form, go into Google and convert this PDF into Word, then MS Word, so MS Word में आ जाएगा. Then you copy not the entire book, but that 13 pages, copy it and then paste it and make it a format. That is the format, and every time you are going to write the report, copy 1, copy 2, copy 3, okay? So basically that also has to be recorded. It's a PN number, 1, 2, 3, 4, okay? Emergency does not have an injury report का 1, 2, 3, 4 file, but I would prefer if you can maintain the file so that you know computer में कितना record होना चाहिए, ठीक है? So sexual assault का भी, if you have a numbering for that, isn't it? So these are the numbers that is there, so you write the report there, or you can take the pen drive home, you can write the report at your leisure time, isn't it? Referring multiple books, and then you finish writing the report and you send a copy to the emergency, to the investigating officer. So it is not the first, second, third copy. Every copy is the copy apart from the original, isn't it? And whenever you do that, after 1 year का तुम्हारा report हो जाता है ना, I prefer converting it into PDF, so that कभी-कभी इसके बाद ज़्यादा दब जाता है, कभी-कभी entity ज़्यादा दब जाता है, कभी-कभी slip on your laptop, isn't it? So it does not alter the report. Okay? After 1 year, put that in PDF, then again go for the next year, isn't it? So record maintenance should have been done like that, organized it, So you can prefer doing that, so that copy is easily maintained and you know what you are writing and why you are writing. And if you have a soft copy and before you want to dispatch it to the police officer, you want me to have a look or any other officers to have a look, isn't it? Then you can send it to us also. You can discuss it before sending the report, isn't it? So you will be confident what you are writing for, isn't it? Right? But you cannot, like, for example, in the previous training course, I have done the training, I have given my visiting card, I have handed out, and one of the medical officer, I think it was in Namchi or Jotham, had called me saying that, "Man, victim aako cha, abu cha ke garnu?" That cannot be that vague. I cannot tell you victim la aera basau hath thama ula bhanau how she is feeling. I cannot teach you from the ABCD. Okay, that much you should know. Then have the basic concept, you can build on top of it, isn't it, right? And while examining, you have to be present. You cannot be over the phone. because that lacks confidence. So, if doctor like that first thing that the patient will think, right? So be in the moment, and then later on you can have a discussion over it. Take as many samples as possible. If you are not sure what you are seeing, what you are looking into, take as many pictures as possible. We can write the reporting. Provided I can consult you, okay? But you don't ask me to sign the paper because I have not posted them. Okay? No, formulating the provisional opinion. This is what I was trying to say. Okay? Let's say there is an injury at the back. Probably the incident happened in a concrete place or something like that, isn't it? So physical injury was there, genital injury was also there, isn't it? Then in such cases, the opinion will be, there are signs suggestive of recent use of force or forceful penetration of vagina or anus, depending on what was the finding, then sexual violence cannot be ruled out. Having been said that, isn't it? Please do not use the word rape. There is evidence of rape. Rape is a legal term. That is for the judge to use. Okay? Like 375 hai, hua hai, definition के अंदर में आता है, to quote unquote their statement, isn't it? By giving the conclusion of the case, right? Rape is a legal word. We are not going to comment on that. Who are we to comment, isn't it? Because whether it falls in the definition of rape or not, that is not our journey, isn't it? Whether there was penetration or not, that is what we are going to comment on. Then if there is a genital injury but not the physical injury, isn't it? There are signs suggestive of recent use of force or forceful penetration of vagina or anus, depending on finding what you had seen, isn't it? It is, if it is the other way around, if there is genital injuries which is absent and physical injuries which is present, then there is, you can report it as there are signs of use of force. However, vaginal or anal or oral penetration cannot be ruled out. If both the things are absent, there are no signs of use of force. However, final opinion availability of FSL reports, sexual violence cannot be ruled out in all the cases because it is a provisional report. Please do not forget to mention that sexual violence is not ruled out. Why? Because there are chances that the person might have suffered but not actual penetration, but through something else when the person was intoxicated or इधर तो नहीं, but outside the rape drug is very common, isn't it? Rofinol is very common. The drink was spiked probably, isn't it? The female might be molested, but if you look at the definition of 375 rape, it might come under the definition of rape and the victim might have come because of that. Okay, so say that the sexual violence cannot be ruled out. Formulating final opinion if there is a penetration. If both the injuries are present and if the report comes that there is positive presence of semen, then in such cases there are signs suggestive of forceful vaginal or anal intercourse, depending on what was the finding. If the physical injuries are absent, the rest are present, then the same opinion will be formed. If the genital injuries are absent and the rest are present, there are signs suggestive of forceful vaginal intercourse. And if both the injuries are absent but semen is positive, then there are signs suggestive of intercourse. Then if both the samples are absent, positive for drugs or alcohol and semen, there are signs suggestive of intercourse under the influence of drugs or alcohol. This is the final opinion as recommended by the Supreme Court that is supposed to be formed. Then if both the injuries are absent for non-penetrative, but obviously FSL will be negative, isn't it? For semen, alcohol, drug and lubricant, there is no sign suggestive of intercourse, but there is evidence of physical or genital assault. If let's say there was only attempted, isn't it? The person might have survived, probably she was conscious, isn't it? If the person was unconscious, the same thing also can happen, okay? But under intoxication, the person with absent physical injuries and negative FSL report, there are no signs for the same. If the genital injuries are absent and absent FSL report, then in such cases there is no signs but there is evidence of physical assault. If both the injuries, genital and physical, are absent and FSL report is also negative, then there are no signs suggestive of penetration. Then absent in both the cases but FSL reports are positive, there is a possibility of penetration by lubricated object, isn't it? Many times, if you can see, the definition also includes the object insertion by him or by making the other person do so, isn't it? That is also included in that. So not necessarily every time the FSL report might come positive, isn't it? So the non-penetrative part of it, isn't it? For example, the person was bitten, isn't it? In such cases, your opinion should not be the same, forceful hai ya nahi, penetration hai ya nahi, That is not the opinion that you are going to write. You are going to write there are signs suggestive of evidence of bite marks on whatever, cheek hair, shoulder hair, wherever it is, isn't it, that you are going to write, and the time of injury. Time of injury will depend on the, let's say it is an abrasion, so depends on abrasion, isn't it? First bright red hoga, then red hoga, brown scab hoga, then hypopigmented lesions hoga, followed of scab hoga, ये सारे कुछ है. I'll discuss that in the later half. Then my class was until 1, no? Okay. So sucking marks, isn't it? If there is sucking marks, bite marks and sucking marks, these two are two different things. Okay? Sucking marks, there is discoid subcutaneous extravasation of blood with or without bite marks present and or FSL detects salivary stains. What is the difference between the two? Bite marks has teeth mark. Teeth mark. Okay? Suckling does not have any bite, the mark of the teeth. Okay? Why it is important? Because there are chances that bite mark means that when you take the swab from the salivary swab loge for the DNA testing, it might be negative. But suckling means there are chances on a fresh hai to the DNA test might be positive of the alleged accused. Okay? So that's why. There are signs suggestive of sucking marks on whatever the site is and the time of injury. Forceful fondling with presence of bruise or contusion with or without fingernails. There are signs suggestive of forceful physical injuries on whatever the site is. Only forceful kissing and FSL detects salivary stains. Then in such cases, there are signs suggestive of salivary contact which may be due to kissing. If the history suggests forced masturbation of the assailant of the survivor, and if there is evidence of seminal stains detected on the hands, there are signs suggestive of the survivor of the seminal fluid contact which may be due to masturbation. In case they previously, remember, we used to write results in double negative. There is not enough evidence suggesting that the person is not sexually potent or something of that sort, isn't it? Now they have been very clear. Okay? If it is there, you have to call the spade a spade, okay? Irrespective of what the investigation is going to lead on to. So if the history suggests, in case there is no signs of sucking leaking detected, but the history suggests some such form of assault, then it is still important to document the history, because the survivor may have had a bath and washed himself or herself. Now, like I said, isn't it, you have to time the injury, isn't it, when the injury had occurred. If it is an abrasion, can you tell me what are the types of abrasion? Scratch, graze. Most commonly, graze in RTA, isn't it? Scratch most commonly in this case of injuries, isn't it? So patent abrasion है, pressure abrasion है, hanging में दिखता है, isn't it? Many types, isn't it? So any of those injuries. Why I say the type, why I ask you the type is abrasion. मतलब सिर्फ एक वो linear scar mark है, the linear abrasion है. That is not the only linear abrasion or the only abrasion. Pressure abrasion is like for in case of hanging, isn't it? It is also a form of abrasion, isn't it? Patent is also a form of abrasion. Let's say गाड़ी में किसी को मार दिया है, वो radiator का छाप है ना? That is also an abrasion, patent abrasion, impact abrasion, isn't it? There are different forms of abrasion. So if it is bright red, it is fresh, isn't it? And within 12 hours. Then if it is reddish cap, it is 12 to 24 hours. If it is reddish brown, then it is between 2 to 3 days. And if it is brownish black scab, then it is 4 to 7 days. After 7 days, the scab dries, shrinks and falls off from periphery. Any questions? Okay. Contusion, also known as bruises. Some books in the toke ones, So you might have had a like stubbing of toe or something like that. At that day, you might not see the injury. After 48 hours, you will see the coloring of it, discoloration of it, isn't it? So red, fresh, few hours to 3 days, blue. 4th day, bluish black to brown, which is due to breakdown of the RBC leading to the accumulation of hemocysteine. 5 to 6 days, it is greenish, that is hematodin. 7 to 12 days, it is yellow due to bilirubin, and after 2 weeks, it is normal. This is just a reference chart, isn't it? If anything in between also it is there, you can say it, isn't it? Depending on the history. Like for example, there are times where I said 7 to 12 days, isn't it? If you want to go with 8, it's up to you. Based on something, you might be saying, maybe there are multiple injuries, isn't it? 1 is 7, 1 is 8, 1 is 9. many of them is 10. Okay, so you might go with that. If I have to do a curve also, isn't it? Sigmoid curve, any of the curve that I'm going to say, isn't it? The mean median mode of it, that is what you are going to take, isn't it? The most frequent is the median. If you take the median of it, maybe that sums up to 8, isn't it? So that's why you have said 88. But if you have said based on that fact, that is a scientific fact, right? You have to say it, you should be able to say it in the court of law also why you had arrived to that decision of 8, right? Like I said, isn't it? After 48 hours, you should call the person for re-examination because bruises are visible after 48 hours. Incise injury. If it is incise, sharp cutting wound, clear cut, isn't it? In such cases, fresh, there is hematoma formation. 12 hours, edges are red and swollen. 24 hours, scabs of dried blood covering the entire area. After their rough estimate can be based on signs of healing, isn't it? There are two types of healing, primary and secondary healing. Primary healing if it is caused by the scalpel or sharp weapon, isn't it? Secondary healing if it is caused due to an injury. Based on that injury, you can say whether the person is, whether injury is like 7 days, 10 days, 12 days old, depending on the chemotaxis, isn't it? Whether the neutrophils are there, whether the macrophages are there, isn't it? Whether the bone is fractured, healed, isn't it? Osteophytes are formed or not. Those are the histological things that you can take up, but you don't, because limited resources, isn't it? But if it is a high profile case, then why not, right? You wanted to take the picture? Although I'm going to give you one, about 2 pt. Okay. Age estimation, that is one of the other questions, that lies in duality of how you should come to an age. The most important thing, if the police says that they have a class 10 certificate pass or like birth certificate or any of the appropriate authority approving of the age of the victim or the survivor, or in the case of accused also, isn't it? In such cases, that will take an upper hand. Today you are not going to fight with that, isn't it? If there is no such thing, then the age has to be estimated. Preferably, it has to be estimated by the medical board. There has to be a radiologist, isn't it? There has to be a pediatrician, there has to be a forensic expert, and one medical officer or like whoever is concerned. Like we used to be the center of referral, so let's say it has come from one of the district hospitals or PHCs, isn't it? So the doctor from there will come along with our board. Then we are going to find make the report of the age. Okay, so medical age is the mean of physical age, dental age and radiological age of the person. The physical, please do not write the test like doctor kindly do the ossification test. Okay. Ossification test as such, like when we have to estimate the age from the bone, isn't it? We cut off the bone. Okay, if this is a long bone, isn't it? This is the diaphysis, this is the body, this is the epiphysis, isn't it? Anything connecting the two is the metaphysis. Okay, so this bone, the end part, isn't it? It fuses, it appears at a certain age and it fuses with the bone, the body of the bone at certain age. That forms the entirety of the bone, isn't it? So at what age this epiphysis comes? At what times it fuses, isn't it? Fuse matlab joltinu. So at what age it fuses, isn't it? That will actually tell you what is the age. So based on that, we are estimating the age. Do you get the defect in this estimation? The estimation is defective because it also depends on the nutrition. It also depends on the weather. For example, warmer fuses early, colder fuses late, isn't it? It also depends on trauma injury that has suffered in the person has suffered in the past, isn't it? Not only the nutrition but the environment and the social upbringing. Fourthly, most importantly, it depends on the genes also, right? So this is quite defective. That's why the paper has an upper hold as compared to that of the radiological finding. The one that you want us to do it, that is the radiological finding. Ossification finding is when we find an skeleton or a bundle of bone, we cut the upper half of the bone. Okay, like let's say this is the long bone, we cut the upper half of the bone and see for the ossification center. And alizarin diata, we dye that. We put the stain that leaves the brownish circle thing at the back, okay, which shows that that is the ossification center and it is not fused. So depending on what age does it appear, what age does it fuse, and what bone it is, we estimate the age. That is the ossification test. And do you want us to do that in a living person? They will hunt us back to the home, call us and then kick us and again send us back home. Okay, so it's a radiological test that you want to do it. The physical age is estimated based on physical growth like height, weight, chest circumference, etc. and also based on secondary sexual characteristics. Tanner staging of breast and pubic hair should be used to determine stage of growth. Like Tanner staging, like I said, isn't it? Depends on the nutrition of the person, the genes of the person, isn't it? How hygienic the person is, isn't it? Based on that, yes, there is a staging done, but how effective it is, we all know that, right? So dental age is important. This is one of the cleanest, easy, non-invasive ways where you can actually say what is the age of the person. Having been said that, most people with the genes in Sikkim is mongoloid, isn't it? So please consider the fact that the third molar usually does not appear in the mongoloid feature. So like if there is not third molar appears between 70 to 25 years of age. So if there is no third molar, do not say it is less than 25, less than 70. Okay? It is one of the features that help us determine the race of the person. For example, cardialis cuspis, isn't it? That happens only in the westerners, isn't it? The shovel teeth, isn't it? That happens only in the mongoloid, isn't it? Depending on all those features, we can say which race the person belongs to. So how many teeth at what age does it appear, temporary when does it come, permanent when does it come, isn't it? It is also essential to identify which is the last tooth erupted, count the total number of teeth and also differentiate which of them are temporary or permanent. Please let me remind you, okay, there are many dentists also, the one with the super specialty also who does not know how to differentiate between temporary and permanent teeth. Okay? So go with your guts. Okay? When I say go with your guts, it means knowledge. Okay? Back it up with knowledge. You know when which tooth appears where. For example, let's say it's a prepubertal age, isn't it? Where there is a mixed dentition, a mix of temporary and permanent. It happens between 6 to 11 years of age, isn't it? So if you know all these teeth are present, so you are aware that within this age, this tooth should have appeared, this tooth should not have appeared, isn't it? So you know these are permanent, these are temporary, isn't it? You have to take that knowledge with you. Okay? So if there is permanent teeth, you are going to mark it with P. If it is temporary, mark it with T. If it is erupted, you are going to put the right mark. And if it is not erupted, cross mark. Okay? And if there is spacing, usually the third molar, what happens is the jaw, the mandible part of our bone, it goes slightly backward to make the space for the third molar. Okay? If there is a spacing for the third molar, although not erupted, please write spacing S in the dental chart. Eruption of the two teeth, also known as rule of halves in cases of temporary. If you say 5, 6, 7, 8, then 1 year, 1.5 year, 2 to 2.5 year. That is easy way to remember it, right? So you know when does it appear. Then the lower central incisor, then upper central incisor, upper lateral incisor, then lower lateral incisor, first molar canine, and then the second molar. That is the temporary tooth which is going to be replaced, isn't it? Replaced by the permanent teeth. This is very easy to remember, that we have remembered it in our undergraduate days, isn't it? That is mama is in bed, baby cried, mama, isn't it? That is, mama is for the molar, isn't it? Is in bed, that is central incisor, lateral incisor, bed is bicuspid. Bicuspid means two cusp molar, that is premolar tooth, isn't it? First molar. Baby cried, mama, isn't it? So second premolar, canine, and then second molar and third molar. That is easy to remember. 6, 7, 8, 9, 10, 11 to 12, 12, and then 17 to 25. Yes, if you remember the first digit of it, it's very easy to remember. And how do you differentiate between temporary and permanent? Temporary are usually smaller, permanent are the larger. Temporary are shinier, permanent are lustreless. Temporary teeth are vertical upper incisors, whereas in permanent teeth it bends, it inclines a little forward and downward as upper incisors. The smooth incisor edge is there in cases of temporary, whereas in case of permanent teeth, they have the serrated incisor because of the meat that you tend to eat, isn't it? So worn out cusp in cases of molar because of attrition, isn't it? And permanent, there is prominent cusp in molars. There is 20 teeth, that is 2 incisors, 1 canine, 0 premolar and 2 molar, isn't it? In case of permanent teeth, there is 32. All the teeth. And coming to the radiological age of it, okay? So these are the minimum that you are supposed to do. This is given by the Supreme Court in the. There are many other ossification centers. Okay? When I say shoulder joint, it not only means the conjoint diaphysis of the shoulder joint. It includes everything: acromion, coracoid fuses in 3 different phases, isn't it? And glenoid cavity, lesser tubercle, greater tubercle. There are so many things that has to be commented on, isn't it? But it has been the limited or concise age estimation has been made, isn't it? So this is much more easier to remember, so you can use this one. The fusion of those with the shaft, like I said, isn't it? There are two types of ossification center, primary and secondary. You should have known by now, I shouldn't be the one telling you this. The ossification center that appears in the uterus, isn't it? Those are known as primary ossification center. The ossification center which appears after the birth, those are known as secondary ossification centers. The primary ossification centers mostly are the diaphyses of the bone, that is the body of the bone, isn't it? Everything that comes later, those are the diaphyses. Those are the epiphyses. Okay? So the body is the diaphysis, the heads and the epicondyles, condyles, those are the centers, secondary ossification centers. So why it is important to know this? Because when asked in the court, isn't it? You should be on tip of it should be at the tip of your tongue that these are the secondary ossification centers and this fuses at this stage, and based on that I've come to the age. Okay? So at 12th age, what you are going to see? You are going to see for the hip joint if there is lesser trochanter appeared or not. If it has appeared, it is in between 10 to 12 years of age. Elbow joint, if the lateral epicondyle has appeared or not, that is between 11 to 12 years. And the wrist joint, if the pisiform has appeared or not. Usually in most book, if you follow the Galston charting, that is between 9 to 11 years of age. But in this case, it has been given 10 to 12 years of age, considering the fact that we live in the Indian subcontinent. I would agree with it. Okay. 14 years. Hip joint, that is central for iliac crest, appears at 14. Elbow joint, center for radial tuberosity, appears at 14. The same thing. This picture also you can have it in your emergency or the radiology department. Okay. 16 years, hip joint, center for ischial tuberosity, appears. 18 years, shoulder joint, all centers of upper end of humerus fuses with the shaft. Like I said, isn't it? The bone, this humerus bone, isn't it? The diaphysis and the epiphysis are there. Epiphysis, what comprises of epiphysis? Or the upper end or the lower end of the epiphysis. Upper end comprises of head of the humerus, isn't it? Greater and lesser tubercle, isn't it? So what it happens is, first the head of the humerus and the greater tubercle and the lesser tubercle, it fuses among themselves, and then it fuses with the body. Same with the lower end also, lateral epicondyle, condyle, trochlea, and the medial epicondyle, isn't it? All these things, they come together, fuse with each other, and then it fuses with the body. Those are known as conjoined diaphysis, isn't it? So what we are talking about right now is the conjoined diaphysis. After fusing with each other, the bony mass, it fuses with the diaphysis. That fusion, we are talking about it here. So wrist joint, all centers of lower end of radius and ulna, that is fuses with the shaft at 18. Hip joint, center for iliac crest, fuses with ilum. If there is only one X-ray plate that you can look for, isn't it? Go for the right wrist. Okay. But Haryana, Punjab, Chandigarh, in periphery, in like remote areas, they do sternum. Like if the sternum comedulin has appeared, they go with the age 18. You know? If it has fused, then it is more than 18. Yes, so less than 18, more than 18, that is what they say. You know? But right end of the, it is one of the NET questions also, isn't it? That wrist joint is the most diagnostic criteria, but it's one of the most assuring X-rays that can say if the person is minor or not. Okay, having been said that, isn't it? If the person is, let's say, the water that she or he is drinking is contaminated with lead, isn't it? Then in such cases also scarring will be formed, which looks like a that the bone has not fused, isn't it? Recently, I also wanted to do a paper on this research. I wanted to do a research on one of the paper. In many of the research journals, international research papers, it is said that the diaphyseal scar that is formed on the lower end of the bone, which looks like the bone has not fused, it remains till that point you die. Like even in 80, you can see the diaphyseal scar, isn't it? So please be sure that it is not a diaphyseal scar, it is the fact that the bone is not fused. Okay, I'll show you the X-ray later. Then hip joint, center of iliac crest with ilium, 21 years, hip joint, center for ischial tuberosity, fuses with the ischial body. Can you see the shoulder joint X-ray? Can you see the part where it is not fused? Right, this line, this line. And can you see that line over there? No, right? Or can you see that? There is no line, isn't it? That means the third page, the third slide shows the fusion of the shoulder joint, whereas the first two, can you guess the age? Shoulder joint. $18 में देखो top में. Can you see that? So in the first two is less than 18, in the later is more than 1, isn't it? This is how the lower end of humerus appears to be. The medial epicondyle, lateral epicondyle, isn't it? There is the trochlea, that is the capitulum, this is the upper end of the radius, this is the upper end of the ulna, isn't it? If you see the upper end of the radius, the head is not fused. How I want you to discriminate between the epiphyseal scar and that of the unfused bone is track the outer lining. Track the outer lining. Okay? If the outer lining is not broken, then it is fused. Here it is broken, right? Can you see this break? So it is unfused, right? So I always ask all my students to track from the outside inward. Okay? Can you see in the lower half of it, the olecranon is also not fused out here and the upper end of the radius. In that picture, you can say that the upper end of the radius is fused. Can you see that? By looking at the previous table, can you tell me the age? What is the age? When it is fused and when it is not fused. Elbow joint, 14 Medico. Center of radial tuberosity appears at the age of 14. So it is more than 14 in both the cases, isn't it? But it has not fused. So this is the X-ray. Just to have a comparison, I have put both the X-rays, isn't it? Can you see the lower end of the radius, which is not fused, right? Track the periphery outside in, isn't it? Can you see that one? It is fused. But this white scar, can you see this? This white scar, do not consider this to be the unfused part of the bone. That is fused bone, fused X-ray. Okay? So do not say that it was unfused and show me the X-ray which actually shows this. It means it is fused. So track from the periphery, you will get to know if it is fused or unfused. So if it is unfused, it is less than 18. Okay? This is the hip joint, isn't it? Can you see the protruding near the neck of the femur? This is the lesser trochanter. If it has appeared, it is more than 12, isn't it? If it has not appeared, then this is less than 12. That chart is just a summation, a little bit of too much of knowledge. It's just the tip of the iceberg. If you want to really estimate this age, isn't it? The iliac crest has not appeared, isn't it? So 14 se kami hua. Then in this case, can you see the triradiate cartilage? It's a fusion of 3 bones, isn't it? Ilium, ischium and pubis. So it has not fused, isn't it? Can you see that? There is a breakage here, isn't it? If it was a continuous screen, you could have seen it, but there is a breakage there, isn't it? So it fuses at 13, isn't it? 13 to 14, 15 to 16 in cases of boys, isn't it? So if you see that, it is less than 13. But if you want to determine lesser than that, can you see this bone? Ischiopubic rami, it fuses at 8.5 years of age, isn't it? Since it is fused, it is more than 8.5 years of age, isn't it? But in that case, it is definitely more than 8, right? It is fused, triradiate cartilage is unfused. It looks like there is a gap on the screen, but it is fused. It is fused, that is a gap in the screen itself. This is the other thing. Many of the seniors, even the people who have retired with the degree, has not seen the ossification center of the ischial tuberosity. Okay? This is ischial tuberosity. Okay? This is ischial tuberosity. When you sit, you are sitting on the ischial tuberosity, isn't it? This is the ossification center. This halka sa line, can you see that? This is the ossification center. Okay? So that's why many of them refrain from using it. Okay? But if we are seeing something like this, there is an injury. This is not ossification center. Ossification center itna hi hoga, halka sa. Okay? If it fuses, it is more than 21 years of age. Okay? And iliac crest, if it appears, itna hi sahi hoga, halka sa line. Can you see that? Itna hi hoga. Anything other than that is an injury or trauma or some disease condition, isn't it? Halka sa hi hoga, that is ossification center which has appeared. Now treatment and guidelines. According to the Supreme Court, the guidelines which has been made by all the doctors from AIMS, isn't it? All the book content mein likha hua, who are the people in the committee who has made this. That is, if clinical signs are suggestive of STD, collect relevant swabs and start PEP Post-exposure prophylaxis, if there are no signs, clinical signs, wait for the lab results. If the person is non-pregnant, isn't it? Then in such cases you can start with azithromycin and metronidazole. If the person is pregnant, you have to avoid metronidazole in the first trimester, isn't it? Hepatitis, if the accused is known to be having one, or for the precaution's sake also, isn't it? Then you have to give immunoglobulin for the hepatitis B, that is 0.06 ml per kg body weight, anytime up to 72 hours after the incident. Then in cases of pregnancy, then you have to give emergency contraceptive, either Maladie 2 tablets or levonorgestrel 2 tablets within 72 hours. Then, although emergency contraceptive is most efficacious, many of them have said, isn't it? Like 72 hours zyada ho gaya, but less than a week, what to do? It is said that is most efficacious within the first 72 hours. It can be given up to 5 days after the assault, provided saying that although you have been given this medication, but its efficacy is less since 72 hours have passed by. Otherwise, they'll again come and sue you for saying that you have given the contraceptive and it did not work, right? So please make that assurance to the patient and give them that this is the situation right now, and although we are trying to save, but it depends, isn't it? A pregnancy assessment must be done on follow-up, and the survivor must be advised to get tested for pregnancy in case she misses her next. In cases of injury like laceration, first clean it with soap and water and antiseptic. If the survivor is immunized within the first 6 months, in the previous 6 months, then no required for TT. But if it is not, then TT has to be given, that is 0.5 ml IM. Then repair and suture the wound. And if there is any fracture or something that you suggest, that is suggestive of deeper wound, then in such cases you can refer it to the higher center. Then PEP for HIV, in such cases within 72 hours the person has to be tested, isn't it? And if possible, PEP has to be prescribed. We don't prescribe it, we send them to the NACO. Follow-up. Please emphasize the importance of follow-up to the patient, isn't it? It is ideal to call the survivor for re-examination after two days after the assault to note the development of the bruise and other injuries thereafter at 3 to 6 weeks. So on 2 occasions you can rightfully call the victim if you feel that you need to re-examine or you are having second thought about it. Okay? You can call the survivor. Repeat test for gonorrhea if possible, test for pregnancy, repeat after 6 weeks for VDRL, assess for psychological sequelae and reiterate need for psychological support. When I say psychological support, I mean establishing rapport with the survivor. Like when I say communicating, communicating does not mean telling the patient. Okay? It means listening to them. Okay? These are 2 different concepts. We have AdCom, nowadays we have AdCom practical. It is a 20 marks practical. Many a times I've seen doctors telling them the history. You are not supposed to tell them the history, you are supposed to listen to them, right? Facilitating and demystifying the procedures, isn't it? They are scared because they don't know what is going to happen to them. It's a mystery for them, isn't it? So if you can help demystify by saying, you have come here, I'm there throughout this procedure, I'm going to be there with you, this is going to happen, this is needed for this in the future, isn't it? And in the future, if you are worried about the finances, this is as the option, the legal aid can be done, given by the court. Even the court, if you like, if you want compensation, that also can be claimed from the court, isn't it? All these things has to be informed to the victim. So conveying messages of validation and addressing feelings of self-blame, addressing suicidal thoughts involving the family or friends, dealing with children, speak to the mother and deal with their feelings. Why speak to the mother? When I say speak to the mother, I do not mean hi, kaise ho aap, theek ho, sab kuch theek hai, not like that. Okay? If something happens to the child, isn't it? It is usually the mother who gets blamed for, not the father, but the mother, isn't it? So in try and talk to them, consult them, give them the counseling, isn't it? And try to tell them that it is not her fault, isn't it? It could have happened with anybody else, because going into that guilt trip is even more worse for the children, isn't it? Because she is the caretaker of that ward, right? So make sure that the mother is also gets that psychological support. Educate the mother on good and bad touch. Child should not be subjected to restraint of any sort. For example, if something of that sort happens, the first instinct is to refrain them from playing, going outside and playing, refrain them from going to the school, isn't it? Please advise them not to do so. Maybe if they want to take a break for 1 or 2 days, isn't it? That's fine. But then ask them to get along with the routine daily works as soon as possible so that it normalizes her daily life. Okay? If you think that you are not able to help them, then please refer them to the professional help. Okay? This is the agency where they are supposed to complain. These are the injuries under POCSO that can occur to the child or incident that can happen which is considered to be illegal. The first authority being the SJPU, then the local police. If they refuse to file the complaint, it is also a punishable offence. The second authority being the SHO, then the superintendent SP, then the special court, then judicial magistrate, monitoring agency, thirdly the High Court, Supreme Court. And in such cases, if they are not, if any violation of the deprivation of the child rights is noted, then in such cases, State Commission for Protection of Child Rights or the National Commission can be informed regarding the same. Now, guidelines for interviewing a child in the forensic interview protocol. When an offence under POCSO is reported, the child's account of the event, that is, the child's statement, should be recorded by the magistrate or by the police officer in the words of the child or as spoken by the child, the verbatim. The statement should be recorded in the presence of the parents of the child or in the presence of any other person whom the child trusts. It is better if the statement is taken in the child's house or in some house where the child is comfortable, and preferably by a woman police officer and in civil dress. Okay, so that it is child friendly. Where necessary, the help of interpreter or translator should be taken so that there is no gap in communication, isn't it? If the child has physical or mental disability, then assistance can be taken. If the child should be made to feel as comfortable as possible and given frequent breaks during the process of recording of the statement. The statement of the child should be recorded by audio-visual electronic means also, because it is feasible now, isn't it? In olden days, it might not be feasible, but it is feasible now, right? So it has to be recorded. If you can, the police officer can scan this guideline. This is the guideline for child-friendly conduct of the police officer, child-friendly police stations, everything and anything that can be done, isn't it? You can scan the QR code, you will reach the PDF. Download it now, because after this I don't think the QR code is, I use this free of cost wala QR code, so it is not going to stay for more than 24 to 48 hours. Done? Done? Okay. The child will also be medically examined if possible. It can be done the very first instance that comes to light without having to wait for the formal recording of the complaint. In cases of POCSOs, without the formal recording of the complaint or FIR, girl children should be examined only by a woman doctor. The medical examination of any child should be done only in the presence of the parents of the child or in the presence of some other person whom the child has trust in. If the parents or such trusted person cannot be found, then in such cases the hospital should ensure that some woman is present at the examination. If, let's say, someone who does not have parents or a local guardian at that time is there, then the hospital or the institution has to direct somebody to be the guardian and give the consent or to act in good faith for the patient. Okay. This is handing over medical reports to and forensic science evidence to police. This I bought it from the Chandigarh Forensic Science Laboratory. They have all the formats there, isn't it? How to preserve it, how to send it, everything is there. You can scan it, keep it with you. This is the way how the samples are to be preserved, how it is to be sent. Same thing, kindly download it because it's free of cost, it's not going to stay for long.
Here I want to talk about Usually the medical officers, when they complete their examination of a survivor, they write in the medical MLC form that the garments, the exhibits are handed over to the police. So here, as per the law, you have to make a proper handing taking memo with the police that you have handed over to such and such TI, and that TI such and such has taken over from you all. Okay, even the IOs should make a handing taking memo when they are receiving the exhibits and the clothes or the victim's clothes. Okay, another thing, when my investigating officer requisitions you or the medical officer for a blood sample, now you don't collect the blood sample. You just write it and you give it to a sister, a nurse, ANM, GNM or a technician. But in the court, you are asked the question whether did you draw the blood sample from this accused or not. Now, I would even advise the IOs, they should be present when they put up the application for requisitioning a blood sample, and also if the doctor has directed any assistance or any technician to draw the blood, he or she also to be cited in your charge sheet, because the chain of custody is not proven. You cite only the medical officer will say, yes, I had directed Phalana nurse to draw out the blood. But you have not cited that nurse in your charge sheet. So the chain of custody for the exhibit or the sample is not complete. So these were the points on which grounds the case was acquitted, even though the DNA estimation had matched. 97% DNA estimation matched. But just because the IO had not complied with these guidelines and there was no proper chain of custody, the case got acquitted. So bear that in mind, and I would also request the medical officers, kindly, when you are examining a POCSO victim or any victim, kindly give due diligence and due attention to it, because your opinion is the final opinion in the court.
Like in the previous slide where I had shown the evidence preservation, isn't it? The same slide, there was 2 columns, right? Where there was supposed to be written the remarks. So you can write it that the sample was collected by sister so and so on duty, isn't it? And you are labeling it, right? I prefer a single handwriting, a single person labeling everything, because there can be misplacement, isn't it? So that's a huge most of thing that can happen. So if you are writing the MLC, take charge of it. So label it, take the sample, isn't it? If you can, then preserve the sample also and hand it over to the police, so that a strict chain of custody is being followed and maintained, right? Then handing over the reports. After examination, the medical practitioner should document the report, formulate the opinion, sign the report and hand over the report and seal sample to the police under due acknowledgement. That is, there has to be a receipt saying that the person has received the report. The investigating officer, the appropriate authority, has received the report. On the last sheet, mention how many pages are attached. Each page of the report should be signed to avoid tampering of the report. Okay, every page has to be duly signed, sealed, and the last page should mention how many pages are there in the entire report. 1 copy of all documents should be given to the survivor, as it is his or her right to have the information. 1 copy to be given to the police and 1 copy must be kept for hospital records. That's why triplicate. All evidence need to be packed and sealed properly in separate envelopes. The responsibility for this lies with the examining doctor, not the medical superintendent, but the doctor who was examining it at that point. It lies with them. All blood samples must be refrigerated until handed over to next in chain of custody. I mean, proper preservation, that is at 4 degrees Celsius, that is in the refrigerator. If the refrigerator is not working, if there is not light, there is no light, okay, or electricity, you are answerable to it. Then you have to say that there is a cooler in our department where we put the ice bag, there I had preserved the sample, okay, you are answerable for that. Till the point you hand it over to the police. Then the hospital has the responsibility for proper preserving samples to hand it over to the police, and each envelope must be labeled as shown in the next slide. That is packet number, name of the hospital and place, hospital number and date, police station with MLC number, name of the person with age and sex, sample collected, examination required, date and time, signature of the doctor with seal. I prefer writing one more thing, properly labeled, sealed, signed and handed over to the police officer whenever you take the acknowledgement of the receipt of the sample. Now, if the person or if the survivor is pregnant, in such cases what you are going to do? An option of undergoing an abortion and protocols for MTP are to be followed, isn't it? Like depending on what weeks it is, isn't it? Now the Supreme Court has extended up to 24 with a single doctor, isn't it? Up to 20 weeks single doctor, 24 weeks 2 doctors. After that, if the patient does not want to carry it forward with the pregnancy, then in such cases medical board has to be set up so that abortion can be conducted, isn't it? Legal one, MTP one, isn't it? And there are other things also. The new law also states that previously it was only the married woman who was considered for MTP, isn't it? Now even the unmarried women are considered for MTP, isn't it? The product of conception may be sent as evidence to the forensic science laboratory for establishing paternity or identifying the accused. The examining doctor or the assistant medical officer or the chief medical officer is to contact the respective police station, ask them to collect the DNA kit from the FSL. So it is not the duty of the hospital, rather the duty of the law enforcement agency to get the DNA kit from that FSL where they want to send to, because every FSL has a different kit. Okay? So that kit has to be brought upon and the form are to be filled by the doctors and bring it to the hospital to coincide with the time of MTP. That's why we were talking about in the morning hours that if we can have an MOU between the forensic science laboratory and us, and we can establish that communication with all the samples already here in the department, and if there is a case we can issue one after the other, that would be within reasons, isn't it? Feasible and rational to do it so also. The DNA kit is used to collect the blood sample of the survivor. The accompanying DNA kit forms are to be filled by the examining doctor. A photograph of the survivor is required in this form. Many of the FSL lab has this thing, okay? So it needs to be sent and should be arranged for prior to the MTP. In cases of product of conception, isn't it? Whatever is expelled from the uterus, in such cases, please do not wash it in the normal saline, put it in the normal saline and send it. Wash it in the normal saline, okay? And then you have to preserve it, collect it in the white mouth container with the lid. The sample is to be handed over immediately to the police along with the DNA kit or preserve it at 4 degrees Celsius. And it is to be transported by the police in an ice box, maintaining the temperature around 4 degrees Celsius at all times. So if you want a tight chain of custody, please make sure that the thermometer is also placed inside the thermocol in the ice box. The vaccine that is being used, if you think the sample is like, there are too many cases, too many samples to be preserved, isn't it? And within reasons it has to be, the thermocol box is also there. I think that falls within the price range of what you can afford. These are my references. And that would be my ID. If you want any help in the future, you can scan it, you can ask for help, but within reasons and within the time limits, not at the midnight. Okay? Any questions? If you have, I am willing to take up that now.
In case of the accused, how do we write the final opinion, given that they ask whether the person is legally performed sexual activity?
See, legally, like scientifically, let's talk about first, you know, how we can say if the person is able to have a sexual intercourse or not. What are the reasons when they can't? One, it could be drug-induced, isn't it? One, it could be congenital anomalies. Third, it could be psychological, isn't it? Fourth, it could be infective disease process. Fourth, it could be trauma also, isn't it? Like injury at a certain accident at the L4, L5 level, isn't it? All these things can also cause injuries, L5, S1 level, isn't it? All these things also can cause impotency, isn't it? How you want to comment on that? If you are telling me, there is a method, okay? First is, one is when you are doing the test, okay? It would be easy if this was a skill lab, then you could have just demonstrated on the mannequin, you know. When you are examining it, there are rest are same history, consent to basically accusement, there is no reason for it, isn't it? But still then for being human, to take the consent, isn't it? If not, reasonable force can be used to take the consent, do the examination. When you are saying clinical examination, based on this clinical examination, I am saying that this person is not important, isn't it? In the word, in the beautiful language, that is double negative, that you are going to write it, isn't it? There are reflexes that you are going to test. One is cremastic reflex. The other one is bulbospongious reflexes, isn't it? These two are the reflexes which ensures that there is nerves, the innervation, afferent and the efferent nerve, that is functioning, that is good enough to have to cause the person an erection. There is no ED, erectile dysfunction in this patient, isn't it? So you are going to write down that there is no evidence suggesting that the person is not capable of performing a sexual intercourse. That's what you are going to form it as an opinion. Having been said that, isn't it, if they want a secondary opinion, there is an ultrasonograph Doppler test that can be done, isn't it? There is other tests, you have read it in a book, it is unscientific. That test, if you tell me, I have clearly rejected. It is obsolete, okay? Please do not mention that test, okay? Cannot be done and illegal, and seems like we have gone back to decades back, okay? So ultrasound, yes, I have completely agreed with. You can see it, isn't it? If you do a color Doppler, if there's a blue and red veins, isn't it? Like blood supply and everything there, and if there's no stasis there, there's no reason that he cannot perform, right? So, having said that, why if we are so sure about it, we have done the test. Based on these two tests, we have checked the nervines, innervations, and we are saying that the person is not important, isn't it? Now, what is that thing that we are going to say that, what will take us to say that definitely he can perform? We are still writing in double negative, isn't it? We are not writing in affirmative words, isn't it? Why? Because there's something like situation, exceptional cases, isn't it? That is quad hoc. Does anyone know what is quad hoc? Quad hoc is when a person has a ED towards a female. Okay, he cannot function or perform to a specific female. Others he can. Okay, so this is psychological thing, isn't it? Can you prove that in the court? Can you do or detect these things in test? There's no way you can detect this test, isn't it? So that's why we are giving the result in double negative. And based on what we are going to give the result is based on the test of the reflexes, cremastic and bulbospongious. If you are still not sure of it, then you can go for color Doppler test also. Anything else? Anything else? I've taken 10 more minutes. I'll take a few more. Okay. A very simple question. Very simple questions, a small discussion. 16-year-old Sarla uses the public bus to go to the hospital, to the school. The bus is always crowded at that time, and she rarely ever gets a place to sit. One day she is standing in the crowded bus. A man behind her presses himself against her. She tries to move away, but there is not much space for her to move. He then puts his hand on her breast and starts fondling it. Sarla screams at him and pushes his hand away. The man says that he has done nothing wrong and that he held her only to keep from falling. As a police officer, what we are going to do? The public has brought the person, that becomes the normal trend, isn't it? उसको फांसी हो जाए, you might want कि नहीं सब jail हो जाए, नहीं सिर्फ fine हो जाए. Everyone has different view on justice, isn't it? But law and order is the same for all, isn't it? That's why we emphasize more on the law of it, isn't it? So if the complainant comes to complain and take support of the law, then we should be supporting that person. In such cases, let's say as a doctor, what you are going to do?
The child is what we call we send an
Police लेके आया है. In that case, you are going to first take the consent for examination, isn't it? Will you take all those samples that you take regularly for penetrative sexual assault? No, isn't it? So please be wary of it, ठीक है? So not every sample. इसमें तो ये है, फिर इसका sample क्यों लेना है करके ना? If you find that maybe later this case can turn into penetrative sexual assault, if that is the reason, mention that. ठीक है? If you are taking that sample, है ना? If it is not so, if this is the only history that is there, please do not take unnecessary samples and torment the patient also, isn't it? In such cases, the man has committed the offence of sexual assault under POCSO. The punishment for committing sexual assault on the child is minimum of 3 years imprisonment, which can extend up to 5 years imprisonment as well as payment of fine. So please charge him. Okay? The second case, Arun is a 25-year-old man. He lives with his brother and is a trusted member of the family. He often plays with his 4-year-old niece Nina, but sometimes when his sister-in-law is busy elsewhere and he is alone with the child, he tells Nina to remove the top and dance to her favorite song. While she does so, Arun dances along but strokes his private part as he does so. Seeing him, Nina also dances with her hands between her legs. He tells her that this will be their own special game and the person who cannot stop as soon as someone else comes near loses the game. If you think of the history carefully, isn't it, then in such cases, can the accused be apprehended? In what case? In what part of it? One is sexual assault, exaggerated sexual assault, isn't it? One is forceful penetration. The other one is exaggerated. Fourth one is sexual harassment. Sixth one is pornography, isn't it? This comes under harassment, isn't it? Yes. Yes, this comes under harassment, isn't it? But when public comes to play, isn't it? They go with literal word of the law, isn't it? So please do not forget to implement the law in the spirit of the law, not only in words. Not only in words, but the spirit of the law. So the punishment for sexual harassment of a child is imprisonment for up to 3 years, as well as payment of fine. Sunita is the mother of 4 and lives in a slum. One day while she was cooking, her 1-year-old daughter began to cry. Sunita asked her brother Roshan to pick up the child and comfort her. Roshan carries the baby, saying he will take her out for some fresh air. When he doesn't return for over an hour, Sunita gets worried and goes looking for him. She also alerts her neighbors. After some time, Roshan is found in a deserted area in a state of unrest, rubbing his genitals against the child. He has also stuffed a rag in the child's mouth so she cannot cry. A crowd gathers and Roshan was beaten. He apologizes profusely, saying the devil had got into him and he would never do it again. The next slide of it also says that although the mother was aggrieved and agitated, but she was forced by the family to take back the case, because it's a family matter, isn't it? And this is a common scenario. This is the most common scenario that you also get to face. Is it not so? Yes, isn't it? Then in such cases, what you are going to do? Yes. So this crime is not reported to the police. This is a violation of POCSO Act also. Okay, so you must register the case, isn't it? Sometimes maybe you are lazy, maybe you were overworking, burdened out, isn't it? Or maybe you just wanted an easy way out, isn't it? Whatever be the reasons, please do not make the victim of an assault the secondary victim of the law enforcement agency and the healthcare facilities too. Okay, please help them in every way that you can. This is the last case. Anup and Akhil are college students. While on a trek in a hilly area, they hear someone crying aloud. They rush to where the sound is coming from and see a little girl in tattered clothes being molested by a man. They shouted at the man and threatened him to leave the child alone. Anup takes the picture of both the child and her oppressor so that it will help the police in making an arrest. The man runs away and Anup and Akhil call the police for help. They are congratulated heartily by the police. All the press gets to Anup's head and he describes the incident in a Facebook post or Instagram. Some of his social media contacts don't believe him and accuse him of lying and then uploads the picture of the child and her attacker as proof. What is the role of the police? For?
Disclosing the identity of the
Any other approach? Out of the box thinking? But the answer is there in the question itself. Anyone? He goes and calls for help to the police congratulates the man, isn't it? Right? So, he could have been cautioned, isn't it? This is the evidence. You need to hand it over to us, and now, since it is under investigation, you have to maintain the confidentiality, since the person is minor, or might not be minor also. In any case of sexual assault, you are not supposed to. Don't you think not only the person, it is also the responsibility of the investigating officer or the person who he came in contact with that he was not informed well, right? So it goes both ways, isn't it? So that's why I say when you do go for community policing, please make sure that all this news and awareness are there, so it becomes the natural instinct. Oi, Facebook par na hale, oi, Instagram par na hale. If you see one foolish writing something, isn't it, posting something, there will be 10 commenting on that, and there will be 500 pseudo-intellect telling them why they are wrong, but still commenting, isn't it? It has a Streisand effect, isn't it, or a butterfly effect, isn't it? Once you talk about something, isn't it, it is heard by 10, then by 20, then by 30. You have to just cut off the communication, isn't it? It was never there. It never happened, right? Never happened. तो नहीं बोलेंगे, but then it will ripple. The news tends to ripple out, isn't it? It tends to confine that ripple, isn't it? So please make sure that the inform is disseminated among the people who is with the case and who is against it also. So Anup has violated the confidentiality provision of the POCSO as rightly said by a sir, and can be punished with up to 1 year of imprisonment. Thank you everyone.
Thank you.